Start collaborating. Righto, team. Okay, this is the first of 2 lectures on property. Property, the concept of property, how it applies in regards to stuff and things, both tangible and intangible things, in our legal system. It's kind of an interesting area of law. The old school barristers and the old practitioners, they quite like practicing in the in some of the more esoteric, the more finer points of this particular area of law. It's also the area that, pardon me, most legal practitioners, legal grads, law grads end up in, because in Queensland anyway, good call. Ravneet, you are a legend. Okay. And so it's an area that it's old. One thing you'll find about property law, it's old. Grads often end up having to do things involving property, particularly to do with conveyancing, because in Queensland, to convey property from one part, both residential property, so property that's owned by people that we dwell in, and commercial property, which is where we run businesses, and as well as farmland, all conveyances have to be done by a solicitor. Now, sorry, that's not strictly true. If you want to pay someone to do it, they have to be a solicitor in Queensland. In other jurisdictions, New South Wales, they moved about a decade ago to having conveyancing clerks, but in Queensland, it's still the case you need to have a lawyer. So it's quite common for graduate law students go out into the world, and that's often, for those that end up in that area, it's often the first thing they end up doing. Which is kind of ironic, because it's also one of the areas that lawyers get sued the most about too, because when people make mistakes when doing things with land, it usually magnifies it, because land has more decimal points, and so that's an area that the way it works for our insurance scheme is often set up very heavily, ends up compensating lawyers that make mistakes in conveyancing matters. Okay, so as I said, this is the first of 2 lectures. We're going to do what we call real property, which is land. So first thing you need to know, just as a technical term, real property is land. Land and things attached to land. Okay, that's where the phrase in English, real estate, that's where that comes from. It's real, actually. Enrico, is it Italian? No, it might be Spanish, actually. It is. It flows from the Latin. Yep. Mm, yeah. Thank you. That's good. And it is old. It's an old area of law. A lot of the stuff um, is, I mean, it predates some rules that would have had you guys, when we talk about the history of British law, which would have been English law, but a lot of the stuff that carried on and flowed from the Roman as well. So the stuff is very, very, very old. But so we look at what we call real property, which is land law, and then we have personal property. So personal property, by personal property, we kind of mean everything else. That actually includes both tangible and intangible rights. And kind of annoyingly, there are a few terms that we use in the accounting sphere which are a bit different in the law sphere. And unfortunately, the use of the word intangible, it has a very specific technical meaning in accounting. In law, it is used as an umbrella term to just describe all forms of rights or packets of rights you get that associate with property that you can't see. So very unfortunately, the main thing to note is that intangibles actually include things like the right to get your money out of the bank account, because that's an intangible right. So it's kind of unfortunate the way that these things operate, and I'll go through the various classifications of the words we use, but just note they don't align, very unfortunately. Yeah, that's life. Sorry about that, guys. So I'm going to start with what is property. What are we talking about here? And the key thing to note about property when we're talking about it in law is that it's actually not the thing itself that we're really referring to. It's about the packet of rights associated with the thing. I'll say that again. It's not about stuff, be it land, or be it buildings, or be it personal properties, my hat, my drink. It's not about the physical stuff when we're thinking about property and property law. It's about the rights that we have, this packet or bundle of rights. That's really where the analysis flows from. Law as a discipline is about the rights that we have vis-a-vis each other, in regard to each other, what we can and what we can't do in regards to other people. Really, fundamentally, it's like taking political science and economics and psychology and throwing them all together into a discipline which enshrines the relationship that we have to each other. We call these legal rules, but really, if you think about them, they are just us being able to enforce our will with other people. And so in the case of property, it's the fundamental analysis we have here is about the packet of rights we have associated with bits of property, be it land, or be they the other types. And we will spend today talking about land and buildings and personal property, and we'll spend next week in entirety talking about intellectual property, which is an important part of contemporary business practice. Okay, so some definitions. Kind of annoying. All right, real property, as I've mentioned, it's land and things attached to land. Okay, so that's what we use when we describe real property. So buildings, obviously, are attached to land, and the land itself is obviously part of real property. One of the things that we do, and I'll look at the test for doing this, is to try and work out whether or not something is attached and is part of the land, or whether it's an item of personal property. And there's a series of tests that we'll look at for determining that. And the reason why it's important is the rules, the legal rules that we have in terms of dealing with real property and dealing with other types of property, both personal, intangible, and tangible property, are quite different. The rules of land law are old. They're very much set up. It's very, very British or very English, I suppose, to be very pro the landlord or the owner of land, and in a somewhat disconcerting way. But we'll explore that a little bit. And you guys, I'm really interested, by the way, for this particular topic, to hear about how land law and the relationship that people have with land in different places in the world. It's one thing it's very, very interesting, because if you think about Australia, it's big. It's really big, and it has relatively few people for the land of the size. And so that how the land is used, and I said I'm from New Zealand, and so there's not as much land, but still a reasonable amount. And then when we look at our other sort of friends in places like Rarotonga or Samoa, places where there's very, very little land, and the relationship that people have to places depends on the geography. And it's an interesting analysis. Has anybody here seen a movie called Lawrence of Arabia? Anybody heard of that film? It's quite old. It's 19. Good work. Yeah, it's well, there's this famous scene where Alec Guinness is talking to Peter O'Toole. Now, Alec Guinness was, for those that may know, is Obi-Wan Kenobi in Star Wars, and he's talking to Peter O'Toole. So he's playing an Arab, even though he's not Arab, probably a little bit politically incorrect these days, but he's playing an Arab leader, and he's talking to Peter O'Toole, who's an Englishman, English soldier, and so that he's telling, and whose name is Lawrence, and he's telling him, Mr. Lawrence, I see you're one of these desert-loving Englishmen. No Arab loves the desert. Nothing lives in the desert. Nothing lives there. And so the reason why that stuck in my head, the relationship that people have with the land and the laws that flow from that relationship flows from geography. A lot of it flows from what type of country you live in physically? Is it a country which is good for farming? In which case, the rules will often be structured around how and where things work in terms of farming. Is it good for the extraction of natural resources? So Australia, for example, has a very, very well developed system in terms of mineral exploration and exploitation. Is there not much land? Again, in Tonga, I visited Tonga about 10 years ago. All land in Tonga is retained by the Crown. You can't have private land. You can have leasehold land, but you can't ever own it because there's so few of it. And interestingly, it's owned by the king. Um, and so that it's an interesting thing to think about, again, particularly because most of us in this class have come from overseas, and it's interesting to go and take stock of the land that we're in here, and appreciate that when the relationship that we've already talked about in this class with Indigenous people in the land, often you'd have groups that were nomadic and would move around, and so that's one way of looking at it. That if the land is large and you move around a lot, would you have different rules to do with the land than if you stayed fixed in one place, and were agrarian in nature? So it's just worth thinking about. Leave that one on the back of your minds when we're going through and analysing this, because the British went all over, and they went over with their boats all over the world and went to all sorts of countries that had all sorts of different structures in place, both social structures but also geographically. Various different places looked and operated differently from each other. And both the blessing and the curse of the British common law is that when you come to a land, their law is received at that time, but it must be adapted to the new landscape that's there. And so if you think about England's tiny. And this idea of having things like pastoral leases, which is an Australian phenomenon, this idea that the Crown would just give people these vast swathes of territory for them to just run their cattle. They don't control it all because it's too big. You send your cows off, and then a few years later you gather them all up again. That's just not how things worked in England, and it's not how things work in India, in New Zealand, in Jamaica, in Canada. It's just the rules are different in different places, and that flows from geography. Okay. Just note here this definition of personal property, because it sounds like personal property is stuff that we own and can touch, but no, the definition of the term is actually to include both. All right, and so this idea of things that are capable of being picked up, we call those choses in possession. I don't know why these things are called that. Things involving property, these are just ancient language. Choses in possession, they're physical things that are capable of being picked up and possessed, but aren't attached to land. Because once things are attached to land, under the test that we'll do later on, they form part of the land, and the ownership of that thing flows to the next owner of the land involved. Yeah, Hina. Yeah, sure. Sure. Okay, here we go. Let's have a quick look. Oh, how messy is my kitchen? Oh, yeah, it's all right. It's not too bad. All right, here we go. Oh, wow. Okay. Okay, lounge. How's this going to look? All right, here's my lounge. We have a television down there. Television not affixed to the land. When you buy this place, if anybody's buying, really good price, going really cheap. If you came into this house, you bought it. Say that you walked in and you bought this house. Would you expect the television to still be there when you came to take possession of it a couple of weeks later? No, probably not. What about that bookshelf? Yeah, that's right. And look, again, we'll do the test for it, the legal test. What about curtains? Maybe, maybe not. What about the fan? And so it's that idea of having some stuff that we think of as being essentially part of the land that forms part of real property, whereas other things that we could pick up and move away are items of personal property. And the phrase we use is choses in possession. I don't know why it's called that. It just is. Now, the form of property rights that we will look at that involve what in law we talk and use the phrase intangible properties. We call these choses in action. Now, I've got some examples of these. Oh, it's a few slides further down. Some examples of the different types of property in regards to that. But just make note, these are just the technical terms that are used to describe these particular particular technical things. So the ones you need to know is real property, that's land; personal property, that's everything else and includes tangible and intangible objects. And that so those tangible things, physical things that are capable of being owned, which is not every physical thing in the world. And how about this is a pretty awful one. Some things you can't own, even though they're physical things, which I'll get to. Waterways, for example, or human organs in our legal system. You are not capable of being owned. Capable of being possessed, but not capable of being owned. And this last one, choses in action. That refers to both what we would consider to be intangible rights in accounting, but also more broadly than that. Intellectual property is a chosen action. Checks are chosen action. Tala, hi. Yes. Yes. Yes, and I have got them on. They come after the fixture. So I've got them, it's like slide 13 when I go through and talk about that in terms of property and the bundle of rights that are associated with property. So we're going to come back to that. I just wanted to just mention these terms at the start before I go and analyze them, these broad terms with a little bit more depth to flesh them out. So this is essentially the four things you need to know: real property, personal property, choses in possession, which are things that that are physical and capable of being owned. So there's and aren't attached to land, and choses in action, which is everything else. All the intangible rights that we associate with property are known as choses in action. It's a very, very broad umbrella term, but I'll get to those. We're going to start with real property. We're going to look at this, and we're going to start with the idea of crown land. Now, when we think of the first, might have been the second lecture for this subject, we talk about the history of the Australian legal system, and that idea that this idea of what we call the Westphalian model, which was that there was no higher power than the nation state, and nation states, even though they didn't like each other, recognized each other's existence. All right, so when one would come to another place, there were sort of these rules in international law that you would either conquer or you would do things through treaty, have some sort of secession, or if there's no one in the particular bit of land, you can just declare it yours by usually literally planting your flag in the land. Okay, so some examples here predating the Westphalian model was William the Conqueror. William the Conqueror, William the First. Was a Norman, which is the northern part of France, and for like thousands of years, the people of the British Isles thought they owned France, and the people of France thought they owned the British Isles, and so they would regularly cross the channel and fight each other for a long time. Anyway, William in 1066 crossed the channel, fought the indigenous king, a guy called King Harold, and killed him, and so he became the king. He tried to make it sound a little bit nicer than that. Tried to argue that he'd had some right through of kinship, but essentially that's what happened. So that was claimed by conquest. 1770 was James Cook's first, maybe second expedition. No, I think it was the first expedition that James Cook had was to find the Great Southern Land and was to claim it. So when they came here, they claimed the eastern third, I think it was, a quarter third of it by declaring it terra nullius, saying, hey, no one else lives here, therefore we're going to take it. Okay, so the idea is that there's no higher power And with no separation of powers, there is only the king or the queen. There's only the sovereign, because they control the military. When they take land through one of those three methods, all of the land vests in them. And so that's where we get this idea of what we call crown land, that the original grant of land flows from the sovereign, from the crown. Okay? Now, so if we just stop and think of it, again, we know, because we've studied enough Australian legal history to know that the terra nullius doctrine was kind of inappropriate because there were still people here, and those people were kind of grumpy about that, as you could imagine. But by and large, the framework still operates, essentially the same way. The idea is that the land that was taken forcibly, what have you, is essentially owned by the crown. That is the original grant of land. The original people or person who gives the stuff away. Now, so if we just start with this premise, again, whether it's a legal fiction or not, it doesn't really matter. We start with the idea that the crown owns all land. So the crown being the queen or the king. And in some places, this is interpreted very, very literally. Tonga, the example I gave before. In Tonga, the king owns all of the land. You cannot obtain a grant other than a lease in Tonga. But the thing is with being the king is that you are the king in the olden days when you have the army and when you can exert control over the realm. Now, that's pretty hard to do because your army can't be everywhere in all places at once. And so the idea is that, look, rather than trying to run everything yourself and having your army around, is that you essentially outsource. You go and you grab a bunch of your buddies, a bunch of your mates, and this is what happened in England. And we say, okay, all right, who's in the list here? Now, if we go through, all right, Roughneads, you can have Wales, just assuming that I'm William the First, and so I've got my friends around and said, okay, Roughnead, you can have Wales, Abhishek, you can have Northumberland, Elmer, you can have Scotland, Franceland, you can have Cornwall, and we just chop it all up. So you have that and you have that. Now, all of these people, and again, this was the barons, all right, so the barons got to have very large areas of England or the British Isles because the king, William, had come and conquered it, and he would just divide it up and say, okay, I'll let you run this land. It's still my land. I'm still the king, and you will owe me fealty. But you, as the barons, can go through and run those particular packets. And what you will do is you will owe me fealty, and you will demonstrate that by giving me stuff when I need it. Give me money, give me food, give me soldiers, horses and weapons, and give me religious services as part of that. Okay, so I'm going to let you run the place. It's still my land, but you can run it. Now, and that group of barons, and remember, I think I talked about it in week 2. Do you remember what the group of barons was known as? Does anyone remember? It starts with P. It's been a long time since week 2. It was called the Parliament. It's not what we would think Parliament is like today. No separation of powers here. They are still doing what the king tells them to. But at the end of the day, they get to run each of these little packets. Now, again, even there, it's still too big for one person to actually run. So what they do is then they get a bunch of their friends and say, all right, all of you guys, I'm going to outsource this little bit to you and that little bit to you and this little bit to you, the little earls, I think they were. And each of you runs that packet, and you will owe me, the baron, money, food, religious services, and horses. And the idea is that it forms a pyramid where you've got, at the top is the king, then you've got the barons, the next baddest people of the land, and then you have things further down, the earls and the knights, all the way down to the people at the bottom, who were known as the serfs. Anyone know what serf, or the Latin surface is? There's another one for you, Enrico. What's a surface? What's surf or surface mean in Latin? Yeah, it's surface. Oh no, surf. SERF. So from service, um, it's the idea of it being uh, essentially like slavery. The thing is, yeah, yeah, server, yeah. And so and so who takes orders? Everybody, yeah, everybody takes orders from the person above them. Yes, perfect, Kamal. Thank you. Yes, the idea is that there's a pyramid, and everybody serves the people above them in the pyramid. So ultimately, the king is at the top. All right. Why is the king at the top? Because the king has the army. I mean, slaves who take orders from all. That's right. Exactly. It's essentially what it is, Hina. You're right. It's because if you think about it, the people on the land, farming the land, couldn't own the land. They had no ability to do that. They worked the Lord's land, but could never own it. Okay, so that's essentially, and then we call that the feudal system, where people at the bottom can't own things, at least not in terms of owning the land itself. You owe fealty to the Lord above it. Okay, and again, you could substitute with other tenants, and we call them tenants. So there we go. So the tenants, the very people at the very bottom, they had to pay the ones up. Those combination of those four things, and they paid up, and they paid up, and they paid up, all the way up to the king. Now, so this is how things worked in the old days, but it turns out it's not very efficient. Why? There's no incentive. People had no incentive to work hard. And I think I remember I said I was going to give it like a 10-minute speech and end up being like 50 minutes about the history of contract law and British Empire. Because the feudal system is great if you're at the top, and it's awful if you're at the bottom. And so that's what happened. And so that over time, they developed systems where people could go through and could go through and work things. And there were certain moments, the Magna Carta being one in 1215, where the barons grabbed the king and imposed some limits on his power. And I'm saying he because they were all kings up until Elizabeth I. Okay, so but this idea though of the essentially the crown or the king being at the top still sort of permeates the law these days, even though the concept of the feudal system, the idea that you have to work on land in order and then give your stuff to the person to do it, it doesn't really work like that these days. We do have the idea of different sorts of grants though, different levels of grants, with the crown holding all of land and then being able to essentially give it to people with some aspect of stipulation. So this idea of having stipulations, in other words, rules or limits to what people can do with land when the crown gives it, or in the case of when the crown's given land and then somebody else gives it to somebody later on, we can have this idea of people being able to give a grant of land, but it must always be the same or less than what we already have. What do I mean by that? If the crown, for example, the crown came here, gave me some land in what we call fee simple, so in other words, without any attachment to it, and said, right, this is now your land, Simon. Great. I could then go and create a lesser grant, a lease, for example. Or I could give it to somebody for the duration of their life, and then it comes back to me when they die. Each of those things is a lesser grant. Okay, and we call that what we call this the Doctrine of Estates. So we have the Doctrine of Tenure, which is the idea of everything flows from the crown, the original grant, the king. The Doctrine of Estates came a little bit later. That's the idea that when a person is given a packet of land, all right, with some conditions, usually they can create another grant to another person of that packet of land with some stipulations. But they can't make the grant any greater than what they've already had. So, for example, if I go and rent a house of somebody, if we think about it, say, who's in there? Say Sukhpreet. So Sukhpreet has a house. I go to Sukhpreet and say, look, I'd like to rent your house for 6 months and paying $300 a week to rent Sukhpreet's house. Sukhpreet has got the house, there's no mortgage on it. And then I can't then sell that house to a third party. I have a lesser grant than what the person who let me in there. Sukhpreet has the grant, what we call fee simple. It's the technical term to describe owning your land outright. One of the things you get is the ability to create lesser grants, more smaller packets of rights associated with that particular land. Hina, yes. Yep. Well, give. The key tricky thing about that question is the word give. When we say we give land, no, I know, but it's really it's the core part of what we're doing. When you're giving something to somebody or selling or whatever have you, you can put stipulations on that in terms of what they can and they can't do. All right, so and I'm literally getting to it in the next slide. We're going to go and talk about the different types. Lease. Yep, that's right. Now, when you go and you create a lease, you're actually essentially binding yourself in contract as well. So again, if I go back to the example, Sukhpreet has granted me a lease. I'm now the leaseholder for 6 months. And the thing that Sukhpreet, as part of that, is accepting $300 a week for this lease, but is also giving up something else, giving up their right to enter the land. There's one thing about it, when you lease your land out, is you give away the right to exclusive possession. That's why your landlord can't just walk into the house at any time they feel like, because they gave that right away for a sum of money every week. Okay, so the very largest, the most important, the greatest right that you can have in terms of land in Australia is what we call freehold land. Okay, it's a right, it lasts forever. So if you own land in fee simple, that's the technical term to describe this freehold land, it means that there's no strings attached to it. It's yours. No one can come and ask for it back. And that includes, interestingly, the federal government. The reason for that is that the Australian Constitution actually forbids it. So the Australian Constitution says that the federal parliament cannot acquire land unless it is on just terms. So they're right. That's not strictly true. They can come and take it back off you, but they have to pay you. They have to compensate you for it. Whereas the state governments, oddly, actually don't have that same rule. So in theory, the states can come along and take your land back, but in practice, they don't. So the federal government, no, they can do it for a variety of reasons. The reasons that it has to be for the good governance of society. But it can be, it can be for a variety of things. So they could do it in wartime. They could do it for, for public amenities. Expanding the airport. There's a famous Australian movie called The Castle. I'll put it in the chat here. The Castle. In fact, I may even just put I'll put the link to the IMDb if I can. IMDb or Wikipedia. It's a movie about an Australian film. It's kind of funny, kind of. It's very, very Australian. We show it to the first years about a family living next to an airport where the federal and state and the local government wanted to acquire it to expand the airport. In theory, they can do it, but they must do it on just terms. So, but from our purposes, though, it is the greatest right you can have for land. Okay, now in the olden days, and I don't know how many people here have read Pride and Prejudice. Has anybody read Pride and Prejudice or heard of it? Does this sound familiar at all? No, you haven't heard of it. No, uh, it's a my sort of female friends that they used to love that thing. Jane Austen, I think. Anyway, it's about a family. So there's a husband and wife in England, and this is old. This is it's set in the early 1800s, so this is 200 years ago, um, where there is a husband and wife who own a big packet of land, but they have, I think it's 5 daughters. This was a real problem because the estate that they had wasn't a grant in fee simple; it was a grant in what they call fee tail. In the olden days, you could have estates that were set up like that they would only pass on to the male heirs. So you could only inherit land if you were a man. And so that it was always um, the next closest male heir would get the land. So even though if I said your husband and wife, you have 5 daughters, the daughters would not get the land. Tala. Probably. Yep. No, not probably. Yes. Yeah. Yeah. And that's what it was in England about 200 years ago. It's absolutely fair. Yeah. You got a good thing you're not in the same room, Enrico. Um. Yeah. 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 It's a tricky thing, but you'll find over time, and I can guarantee you this will happen. Yeah, it's an interesting thing, and it's hard because I come from a very, very egalitarian society. It is New Zealand is much more progressive than Australia. It's very, very noticeable as a person that's lived in both. Your mum's the best. um, and so I found that over time, refrain. No, that's all good. Except this is a short lecture. You guys can. I'm really interested to hear. It's. I mean, from my perspective, I think it's really interesting. I had to study some of the Sharia in for my honours thesis, which was on the law of obscene publications and exhibits. And so I found, yeah, some interesting things where some places in the world where the criminal code, the Queensland criminal code, we call the Griffith Code, is used. It used to be in Italy actually, but Mussolini got rid of it. Um, and Nigeria and PNG, and the Nigerian one's really interesting because in places you see the Islamic, the Sharia influence on it, and some of it's pretty scary. The if you went and told somebody in Australia um, the equivalent, I think it's sexual assault. I think it might be the rape, sexual assault, or some one of the criminal sex provisions. Uh, you can't be found guilty of it in Nigeria based on the uncorroborated testimony of just one woman. If you told that to an Australian woman, oh, they'd go, yeah, that wouldn't fly here. Hasn't fly. Wouldn't have gone for long, but it was just interesting. I found from a legal academic perspective that it was the same code. It was the same criminal code that was put in place, but it had modifications to it. Yeah, yeah, Tala. Hmm. Yeah, it's difficult. It's difficult in regards to human rights. That's the real difficult thing in there is because remember that law and legal system is it's fundamentally grounded in rights. So here we're talking about property. This it's about the rights that we have in regards to each other, because you can have um, structures that are in place. For example, here in my I'm just trying to think of examples in terms of formal equality and making things equal for people to go through and do that. Change argument, I think it is the best. And it's difficult to derive things like that from first principles. And so at the end of the Second World War, the they came up with a Declaration of Human Rights. The Universal Declaration of Human Rights, and that's the idea that fundamentally as human beings, we have and share the same dignity as part and parcel of that. Now, we know that there are people, for example, for what a variety of reasons, mentally infirm, elderly people, um, children, that in terms of packets of rights have to operate or have been modified differently. But it's very, very difficult. It's a difficult thing. I found when going through that, I couldn't find uh, any from first principles mechanism to justify it. But I will say that this example, so that where we've got this idea of fee tail, was very much the law of the British system. It very, very much was. So I said when Pride and Prejudice was actually based, the whole story is based around the idea that there is an estate and they had 5 daughters. And so the difficulty there is that they wanted to marry them, find an appropriate, good man to marry them to as part of the process. And that's really how the whole story sort of pans out as a result. And you would be very surprised how late in the piece it was before fee tail was abolished. In fact, I'm quite interested to know. Fee tail, I think it was in the 60s. I'll just check. Just trying to see where it was. It was definitely in the 20th century. Queensland was certainly abolished when the Property Law Act came in, but I'm not sure whether it was abolished before that. It was in 1974. It's possible it was before that. The abolition of estates tail. So Section 22 of the Property Law Act abolishes it, but I suspect that it was actually a little bit earlier than that. I think in England in the 20s. Trying to see where it is. Australia, I can't see. I haven't got it down here. Okay. I think the British did it in the 20s. I think they got rid of it. Not too sure. Anyway, it carried on for a really long time. So if we think about Australia as being progressive and this, that, and the other thing, nonetheless they don't change. And look, and that really, it's kind of similar to how land law works. That land law, they don't change it quickly. Things move very, 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 very slowly. And what you find though with that type of grant is that the courts, for whatever reason, in situations where a person has obtained the grant, you could go and ask the court to remove that or to reclassify that in some way. Okay. Now, an important one here is though, so fee tail does exist anymore, but life estates do. That is this idea that if you have a particular packet of land, all right, and you own it in fee simple, remember that's the greatest grant, which means you can grant a lesser right. One of those lesser rights is a life estate. What that is that you can name a person, usually it's by gift, and that it lasts for that person's lifetime. And again, by default under statute, that person can't on-sell it. That's a statutory rule, not a common law one. But it possibly is actually, I believe if the grantor allows it, you can override that rule as well. But generally people don't. Where would this come up? Let's just say I have for example, if I'm elderly and I have a much younger wife, for example, but I have children from an earlier marriage, all right, I could create a grant that my wife, who's probably going to outlive me, can live in the house and treat it as her own for the duration of her life. But when that ceases, it then goes to my children. Okay? That's how life estates work. A person, you have what's called the tenant or the life tenant, and then you have what are known as the remainder men. So once this finishes, they get the residue of the estate. Why is this a problem? Well, particularly where you've got income earning property. So if you've got a life estate, remember that you're still granted the ability to use it. But you don't have to live in it. You can go live somewhere else. So for example, I have my much lesser younger wife. Let's call her, I'll call her Karen, because it seems to be every girl I seem to date these days. If Karen outlives me, I die, and I say, when I create the grant, that when she dies, it goes to my son. Okay? Yeah. A life estate is for life. Yeah. That's life estate. Mm. Uh, I mean, I don't know. I'm not really following how things are in terms of how things work here. If you, if I have freehold land, say I own this house, all right? I own this house. I can grant a right for another person to live in it, a lesser right. I could grant a life estate. I could even do it while I'm still alive. I could literally say, I'm going to create a life estate for Karen, my girlfriend, who isn't actually younger than me, she's older, but assuming she was a lot younger, and I could do that while I'm alive. All right, that she now has the estate and she owns the land for the duration of her life, and when she dies, the ownership, the grant reverts, and it would revert back to me, but I'm dead, so it would go on to who I've declared as part of the grant, which is going to be my son. Okay, when you map it out to do that. Lovely. Yes. Um, it doesn't matter. You can't. Well, I mean, the the estate itself is still keyed to her life, regardless of whether she remarries or not. But there is a bit of a problem, as you could imagine, though. If you do have a property, we'll say real property, and it earns income, there is a tendency for the person owning it, the life tenant, to use it up. Why? Because it's expensive to maintain properties. You don't want to have to do all the repairs. You want to basically get as much out of the income because you're not going to get the capital and remainder at the end. Whereas the remainder men, they don't want the person to draw the income out. They want to maintain the capital asset, keep the house in as good condition as possible, because when the person dies, they will get the thing, the capital asset. So there's this trade-off between these two types of things, and it comes up more in trust law as well as land law, where their interests are very much competing. So assuming that I died and Karen has this house and she's living in it, all right, there would be almost an incentive for her to not repair it. Does that make sense? Because her spending money maintaining the house, maintaining its capital worth, there's no value to her in the place increasing in capital gain. There's no value in her improving it. There's no value in her spending money to do capital works to add extra bedrooms and bathrooms. So that the courts know this, and you actually can apply if you are a remainderman. So Peter, for example, my now 9-year-old, could actually go to the court if there was some evidence that Karen was wasting the land in some way, wasting it, damaging it, destroying it. Okay, so that if it was fee simple land, my house, I can let it go to waste. It's my house. It's me who suffers. Whereas if you've got this split between the two, this life estate, then the remaindermen, there's a trade-off between these two things as part of that. Okay, all right, so that's what a life estate is. Yes, fee tail doesn't come up. Fee simple is the greatest grant. You can have a life estate. Hina, yes. 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 Yes, yes. Under the Property Law Act, you can bring an action, essentially, to get the court to declare the person is wasting the land, and that he, as a remainderman or a person that was going to get the estate when she dies, can ask the court to give a remedy. In other words, usually get some form of compensation from her for wasting the property when he's the remainderman. So yes, you can. They can go through and do that under the doctrine of waste. Okay, so that's a life estate. Now another and a really important thing in terms of business law is a lease. All right, so what's a lease? A lease is a right to have the property for a fixed period of time. That's it. That's literally what it is. It is a lesser right, and when the lease expires, the property just reverts back. So the right to possession just reverts back to the person granting it. So you note though, remember that you can't give if you have a certain type of grant, you can't give a greater one than what you've got, or even at the same level. So that if you have the land in fee simple, you can grant a life estate, you can grant a lease. You can grant a license too, which is even the lower one. Whereas if you have a life estate, you can still lease the property. So again, after I die, if Karen's got the land as a life estate and Peter is the remainderman, Karen can rent the house out and collect money from it. She is allowed to do that. That is a lesser grant than the grant that she already has. Similarly, if you are or have a lease on a place, the grant that you can give people, there is one grant which is even lesser again, which is what we call a license. You can grant the ability for a person to come onto the property for a particular purpose. That is called a license. I realize I don't actually put a slide in for it. That is a lesser right than having a lease, which is a lesser right than having a life estate, which is a lesser right than having the land in fee simple. Okay, and the types of laws, the statutory rules that we use in terms of leases are actually contained in a variety of different statutes. So the one that we get exposed to the most in our personal lives is the Residential Tenancy and Rooming Accommodation Act, the RTRA. It is has all of the rules that people have in regards to as tenants and as landlords of residential property. Okay, residential property is governed by that, and it basically takes the basic rules of contract law and modifies them. That's essentially what it is. So all of the rules we've had about contract, offer, acceptance, intention to create legal relations, capacity consideration, all of these things still apply, but it's heavily regulated by that. For example, so that you can't, for example, have a residential tenancy and not register the bond with the residential tenancy people. right? Now, we know that there are all sorts of ratbag landlords out there. And I've done quite a bit of residential RTRA, just giving legal advice, doing volunteer and community legal work. And people ignore it all over the show. But strictly speaking, it's still the law of the land, and there are penalties that are associated with these things where people don't apply. That's the situation where the regulator goes through and can bring actions against landlords that just don't bother playing by any of the rules. Similarly, tenants can not play by the rules. Tenants can leave places in an absolute mess. And the whole reason why they have a system of bond for residential tenancies is really, look, to be honest, it's actually to protect landlords. I'm not sure. I'm interested to know. In Queensland, the minimum length of time is 6 months for residential tenancies. What is it in other nations? Are there fixed statutory minimums for tenancies? What's it like in Lebanon, Tala? What's the minimum length of time that you can have a residential lease in different countries? I'm really interested. Not the minimum. 1 year. Oh wow. Okay, that's interesting. Don't do less than that. You know what? Yes. Yep. Yeah. Um, is that in Australia, in Queensland? Oh yeah. Okay. It yeah, it's the conditions that people can have. And look, there are some statutory rules from this. So you take the basic rules of contract law, which in theory means you could rent it to somebody for a day. Um, but in practice, the way that residential tenancy works is that it's got to be a minimum of 6 months. And look, the reason why they have the statute, it's to really try and have this balancing act between the rights of landlords, because we want to encourage people to build all sorts of extra property and run it and manage it and maintain it and pay the rates and do things, to do this and create a service for others, to provide privately provide people with houses to live in. Okay, ideally we do want to encourage people to do that, but we also want to protect tenants from having really unfair clauses and terms. Because one thing in particular, if you're a tenant, having to move all the time is awful. It means that you don't have a sense of home, you don't have a sense of belonging, and you're at a power disadvantage if landlords can just change the rent arbitrarily when they feel like it. That's why we have these things in place. Yeah, most landlords power. Yeah, they do actually. I do sort of say that. And interestingly, in New Zealand, 3 months is the minimum, whereas here it's 6. Tala, yeah. Hmm. Yep. 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 Yeah. Yep. Yeah, that's right. Similar things happen here too. I can't remember. It's either one, no, I think it might be 3 months without. You can give notice without reason, but I think it's 3 months in Queensland. I can't remember off the top of my head. Um, and so these things, look, it's actually worth going through and doing it. I again, if I was doing this in a face-to-face class, I probably would show the thing on the screen and bring bring that act up and actually show you guys, because it's quite a readable piece of legislation. Um, and just note though that that applies to residential property and rooming accommodation. Rooming accommodation are short stay arrangements. So short stays where you pay sort of 2 weeks. That's where people go into places that are fully furnished, and are just essentially staying for that short periods of time. Um, but note that when you go to a place like the mall, like Stockland, the mall in the middle of in the middle of Aiken Vale, that's governed by its own piece of legislation, the Retail Shop Leases Act. Why? Because we think of the relationship between tenant and landlord. Landlords usually have more power, and so that they needed to sort of regulate that in terms of the imbalance. When you have something like Stockland, the where you've got a business in a mall, again, the owner of the land has a lot of power. That not only are they have the ability to just do bad things to you, kick you out, move you out, close your business down, not do what hell have you. They also are large commercial players as well. So that the Queensland Parliament has come in and created this thing to regulate it. Why? Because small businesses are at a massive disadvantage when dealing with large entities like Stockland and Westfield. They're large, powerful players that know that law very well. If you've just got a business, you're a little business selling board games, and you've got a little lease in Stockland, you've got no way of negotiating stuff, and so that they do have to put some protections in place to stop some unfair practices from happening. Okay, the last two things. The last two statutes, the Land Title Act and the Property Law Act, they are the statutes that govern the transfer and registration of land. Land Title Act is the transfer and registration thing, which tells you that all contracts for land have to be in writing and they have to be registered. So every packet of land is mapped out in the state of Queensland and has one owner. Okay, all of the other information is still stored on there, but it's important to note that what we call the indefeasibility doctrine says there can only be one owner at a time. Now, it sounds silly when I say that. So obviously you've only got one owner. Well, things are problematic when there's fraud, particularly where we've gotten there's a whole bunch of cases involving this where a husband and wife, and the husband or the wife will fraudulently sign away rights to the property. Okay, often to people to borrow money, take the money, disappear, lose all the money, then the property has to be sold, and then the poor husband or the wife who was innocent still loses their property. Why? Because you can only have one. It has to be the person whose name is on the folio, the one registered owner, has the legal interest. It's not to say the others don't have rights, but they're not the legal owner of that. And the Property Law Act has things about land and real property, but it also has all the rules to do with every other form of property, equitable property and choses in action and so on, and that as well. Those are the rules for assigning property as part of it. So we'll leave it there. Just the one sort of takeaway I just want you guys to have in terms of leases is that it is governed by contract law. When you have leases, and for you guys that are going to go in business and you are going to be analyzing things, you are going to have to use principles of contract law, the objective interpretation test, when you're interpreting leases, because they are contractual instruments. And so those things require negotiation and careful reading of the terms contained within, because particularly for commercial arrangements between players, you're considered to be sufficiently powerful and know the common law rules of contract. So leave that one in the back of your mind. Now, I think we're going to take a few minutes here before I start on the next topic. So I'll come back in a few minutes, if that's all right. I'll take 4. So 3 or 4 minutes, I'll get myself another drink. Okay, right, moving on to the next slide. Look at co-ownership. This is something that historically I'll assess. Historically I have, and historically I will. One of these difficult things about this topic, guys, is that it's a little bit all over the show. It's, there's no real easy way to sort of move from one logical progression to the other. It's not like contract where you can chop it up into those 4 blocks. Land law is a little bit. Um, here's some rules, and here's some more rules, and here's some more rules, and a lot of them have been developed literally over 1,000 years. And so I'm just, you know, I'm a little apologetic because I feel like I'm just firing some slides at you guys. Here's a piece of information. Here's another piece of information. And trying to get stuff that sticks can be a little bit annoying. The upside is it's shorter. There are just fewer slides, but there's a bit more to talk about here. Okay, and this one also looks a little bit more like the style of slides that you would have seen from me in this subject, where there's a statement of rule of principle and a source. Statement of rules, principles, source. It's how I prefer to create material. I find it much easier to do things like that, where here are just a series of legal rules. We're going to go through and talk about them, and you'll need to sort of be able to explain them back to me or whoever's marking your work and apply them in short scenarios for the next 2 pieces of assessment. Okay, and what else? I've also, by the way, I've actually taken I have taken all of the material and put it in the subject resources, what do you call it, folder. So there's a subject resources folder on LearnJCU. It's under the learning activity. There's a file there that's called CO5119 All Topics. I've taken all of the lecture material all the way to the end of the semester, compiled it into a single Word document. Which I've been meaning to do, but to be honest, I couldn't do it till I was quite late in the semester before I could get that to you. So you guys, I wholeheartedly recommend that you go through, grab it, use it, modify it, do whatever you like to it. It's just all of the slides written out in a doc. So I hope that's helpful. Okay, co-ownership. This is this is actually pretty important. Yeah, this is important. All right. So what does co-ownership mean? Well, as you can imagine, you can own bits of personal property on your own, but you can also own them with other people. And you can own real property on your own or with other people. Now, it's quite unusual for items of personal property to be co-owned. It can be, though. Business partnerships. You guys may or may not know that business partnerships are not a separate legal entity. It's just all of the various partners in a business, all binding each other in contract and in tort. And so it's not uncommon for partnership property to be jointly owned by all of the partners. That's one way they can come up. But to be honest, the most likely situation co-ownership is going to come up in your life is more likely in your personal lives if you own real property, if you own land with other people, and usually those other people are family members. So I love this part. I love this part because it's one thing that we notice when we're talking about this, and I'm quite curious to hear everyone's thoughts are. We were talking about our own family members. So think for the moment about your parents, if you happen to be fortunate enough to still have both parents, and your siblings, if you're slightly less fortunate enough to have lots of siblings. And think what it's like, and think how things are going to be if you had to own real property, so land and buildings, with them. Okay, what would you want? If I, for example, had to, I've got one younger sibling and 2 parents, no grandparents. In fact, ironically, this exact moment last year, the break when I was teaching land law, I found out my last grandparent had died. That was 12 months ago. Good golly. But the ownership of husband and wife arrangements is usually done together. So, if you are acquiring land with another person, be they a family member or a partner, life partner, you need to know these rules. These rules are very, very important because there are 2 types and they have fundamentally different rules about how they operate and how they can be alienated and what happens next. It's all about the what happens next with these things, because everything's all fine and good until something bad happens, usually until one or both people die. Okay, so first thing you need to know is the two types are known as tenants in common, and the other type is joint tenancy. So these are the two ways you can co-own real property. Tenants in common or joint tenancy. All right. The first thing you need to know is that in either situation, you don't own, all right, a certain physical half of the building or land. That's fundamentally not how this works. Joint or co-owners of land, regardless of the two types that you've chosen, are always going to have the right to access all parts of the particular packet of land. All right, so that's it. So say, for example, going back to Karen, my girlfriend's called Karen. Let's just say that we owned this house together. All right, we can't stop the other person legally from entering the house. Okay, we can't. We just don't have that particular right at common law. Okay, you don't have that right. If you're a co-owner of a property, you have the right to enter it and use it. That's the first thing. All right. If you are if you force the other person out, and in Queensland more recently, the example comes up with domestic violence. If you force the other person out, you are obliged at common law to compensate them the equivalent amount of rent. Okay, we'll call that occupation rent. And that will apply regardless of whether you are living in it or not. So if you force someone out of the house, right, then you rent it out, and it was unreasonable for them to sort of come back and try and claim their rights, you as the person who's kicked them out are going to have to compensate them. And again, usually it's the fraction. So if there's two people that either co-own the property, you're going to pay half the equivalent of the market rent. So say, for example, this house, it's got a market value that's come in. We'll say it's $300,000. It's not. It's less than that, damn it. But we'll say it's rented out at $300 a week normally. That's the market rate for rent in the area. Assuming that Karen and I co-owned this house, she actually is a black belt in Taekwondo. So assuming that she inflicts domestic violence on me, and I'm forced out of the house, yeah, you'd never know meeting her. If she had forced me out through domestic violence, and it wasn't reasonable for me to come back into the house, regardless of whether she rented it out or what she did with it, should be obliged at common law to pay me $150 a week. Okay, that's the first thing. Now, if there's no domestic violence, that's not the case. However, under the family law regime, the person who remains in the property is expected to pay the rates, electricity, internet, and so on like that, which is actually the situation I have with my ex-partner here. Okay. So that's co-ownership. They have these things. Now, co-owners can't make other co-owners pay for anything. They can't. You can't make that. If they don't want to pay, they don't have to pay. Okay, to make additional contributions. All right, that's additional contributions to upkeep. They have to pay to maintain to a certain standard, but you can't make them do things. All right. Now, if one person, or I haven't got it on the slides there, decides to make capital improvements, that co-owner cannot make the other co-owners pay for it. However, if the property increases in value, all right, then that person who did this extra contribution can be compensated if the whole property is sold at some stage later. All right, it's not fair for that particular share to be allocated or shared across the co-owners. Okay, but by default, you cannot force other co-owners to contribute. That's just the way the law works. Okay, so all right, those are the two things about co-ownership generally. Now, the important rules, the really, really super important rules, you're gonna have to know. You will be assessed on this. Is this difference between tenancy in common and co-ownership? Okay, in tenancy in common, Abhishek, hi. Mhm. Yes. Leases are not is not co-ownership. Oh, sorry. Yeah, go on. Yeah, go on. Yeah, no, you could have a lease. Sorry, I take it back. Yes, you could have co-ownership. There's a lease. Yes. Yep. Yep. Hmm. Yep. Ah. When if you want to, thing is with land law is that it's mapped out. All of the instruments have to be in writing, and they have to be registered, so that it gets harder and harder as time goes by, in Queensland anyway, to be able to have instances of fraud to try and sign things over to certain people or to try and get some benefit where things aren't mapped out because land is valuable and because it's all mapped out and written. And these days, electronic documents, it's kind of hard to go through and do those things. But the key thing to note about joint tenancy is what we call the right of survivorship. If there is one defining characteristic of joint tenancy and how it's different from tenancy in common, it's this right to survivorship. Abhishek, how many siblings have you got? How many brothers and sisters? You're the only one. Oh, you're an only child. Oh, blessed that man. Yes, blessed. What about some of the others? Who has lots of siblings? Nathan, who's got the most? Go on, Hina. Hina, how many siblings have you got? Oh, good gracious! And Nathan's got three. Hina's got. So is that Hina? Does that mean there's six of you in total, or is it you plus six? Okay. All right. So I'm going to use Hina as the example here. Okay. Let's just imagine your parents have got a few houses, which they possibly do. Let's just say that they've got. Let's say they've got one large expensive property. Okay. All right. And let's just say that, and again, so Hina, I have to ignore everything to do with Sharia in terms of this. Let's just say that for whatever reason, your parents decide just before they're about to die that they will, in Queensland, yeah, just ignore it. Thanks, Tala. Cheers. Um, is that we will allocate or grant this to you guys, all right, just before they die, or they put it even in their will after they die. They give it to you and your siblings as joint tenants. Okay. What that would mean is that all six of you would have the right to enter the property. You'd have the right to use it, right? And you couldn't force anybody. You couldn't force anybody to actually pay for anything there. Although if somebody is forced out, they would have to be compensated. But very, very importantly, let's just say each of you and your five siblings has one child. Hypothetically, I know, Hannah, that you've got more than that, but let's just say we've got is one because it makes my example easier. Which of those children, of those six children, of the six siblings, is going to receive the property if there is joint tenancy, if it's held by their parents as joint tenants? Who's going to get it? See if you guys can work that one out. Yeah, it's interesting here. With the youngest, all of them. No, none of that's complete. Have a read of that sentence again. A joint tenancy is where they have full ownership. So just so Hina, again, we're thinking of Hina here. She says Hina plus 5 siblings. All right. They own a big plot of land and they own it as joint tenants. All right. And each of them has one child. In 50 years, how long are we going to live? Oh, I'm not going to ask him. We'll say in like 80, however many years' time. All right, we're going to assume all 6 of Hina, sorry about the story, Hina, but Hina and her 5 siblings have all sadly passed away, and each of them had one child. How is that going to be owned after all 6 of those siblings pass away? Who is going to own it, and how? You just have a read. Oh, hang on, one at a time. We'll start with and Hina, go first. Hina, go first, then Aniko. That's right. Marie's got it there on the screen there. If you read that rule, they all have full ownership. They can't transfer it, and that passes to the co-owners upon death. What that means is that Hina, amongst you and all your siblings, the last person to live gets the whole thing. That is joint tenancy. And that's why it's seriously old school. What that would mean is that one, assuming that each of you and your 5 siblings had one child each, one of those children gets it all and the other 5 get nothing. That's how joint tenancy works. Why do you think that would be? Abhishek? Oh, it's not. It's awful. Yep. Yes, you will. You will, but yeah, that's right. But here, if it was owned by the siblings as joint tenancy, when one of them dies, it cannot pass to their heirs. It cannot pass to them. It can if it's tenancy in common. This is the difference between the two things. If instead of a joint tenancy, Hina and her siblings had 1/6 of the property, that 1/6 that Hina has could pass to her single child, or she could sell it to third parties. That is a share which is calculatable. And again, you can work it out as a percentage, what 1/6 is, 16.5% or whatever it is. And that is dividable and that can be passed on. So tenancy in common is where property, real property, is essentially divided up in terms of ownership, right? And those shares, those packets of shares, can be bought and sold separate from the others. Joint tenancy has those 3 rules: full ownership, can't transfer it to third parties, and when the person, all of the joint tenants, when all of the other joint tenants pass away, the last one surviving gets the entire estate. Hina, yes. To take it, as in to become the. Yep, yeah, sure, but that's governed by contract. They have to pay the other owners in order. Yes, absolutely. Yep, your 5 siblings, you could buy their shares if you wanted to. If you wanted to buy them out, and if you buy all 5 other shares, sure, it's yours. That's right. That's how that works. So that you can't, once you've bought the shares, you actually, assuming it's you buying each of them, they actually get extinguished. So that you don't, it's not that you have 6 separate packets of 1/6, it's just you on your own. So if you have 5 siblings and you buy the first one out, all right, you now own 20, whatever it is, 33%. You now have 33% of the ownership. And then if you bought another sibling, so now that you have 3 out of the 3/6, it would then be half. You'd have a half ownership of it in terms of tenancy in common. The other two would still have 1/6 each. That's how that works. So that's very mathematical. That's the bit that makes sense. And you can sell it, absolutely. Absolutely you can. And I've seen some really sad tales where families have had things in tenancy in common and then cracked it and sold it to others, and it got really awful. Because the whole reason, by the way, is that if we think about this idea of landlord coming from the laws of ye old England, the whole reason why we have it and we have joint tenancy was actually to try and keep large estates in the family. Okay, so going back to that Jane Austen example, it's keeping it in the family so it stays together, doesn't get chopped up. Otherwise, every generation would chop up the estate and have smaller and smaller and smaller packets, each of which becomes less economically viable. Sorry, Abhishek first. Sorry, Nathan. Just Abhishek first. Yeah. Hmm. Yep. If it is tenants in common, they can put, it's one of the packets of rights that you get when you own property, is that um, you can get you can dispose of it to whoever you like. It's one of the defining features of property. If it's tenants in common, I own a 6th share, I can sell it to whoever I like. If it's a joint tenancy, I cannot. Okay, I cannot do it. Yep, sure. Yeah, no. Yep, yep. Yeah, that's right. That's right. That's essentially the same. Well, appreciate that the last surviving sibling. So going back to Hina's example, if she's the last surviving sibling, sorry, Hina, give you the example. All your siblings have passed away. If she's the last one, it's actually no longer joint tenancy. She's the only person who owns it, so she can do what she wants. If she wants to put it in a trust, that's fine. If she wants to create a new joint tenancy amongst each of the children of her siblings, so her nieces and nephews, sure, she can do what she wants. But the key thing is, she doesn't have to. She will be the owner in fee simple because there's no other joint tenants at that point in time. That's the key thing. She can do what she likes at that point. She's not obliged to. Um, that's really the defining characteristic of this particular aspect of land law. And so this idea of co-ownership is something that, yeah, again, we usually do assess to some extent in terms of this because it can come up because land is expensive. Land is usually the biggest purchase that each of us make in the duration of our lives. And for those that again do have siblings, when you are going through the awful, messy process of dealing with wills and estates and families can be difficult. So just having and knowing these rules in the back of your head, even though generally it comes up more in our personal lives than professional ones, it's helpful to know. But I'm going to move on. Just a little bit mindful of time. I haven't got through these as quickly as I was expecting to. So co-ownership, you probably want to tuck these rules away in your head. Well, I do need to know. And look, I actually am going to, just as a caveat, say there is actually a statutory mechanism where you can apply to the court to sever a joint tenancy and convert it under the statute, the Property Law Act, into a tenancy in common. Because joint tenancies create really grave injustices. The courts historically have hated them because it means, if you think about it, going back to Hina's grandkids. So if Hina's parents had this one estate, 6 kids, and they all have 1 kid each. It creates something of a grave injustice from our perspective that one of their grandchildren gets all of the estate and the other 5 get nothing. Something about that we find inherently troubling. All right, but just to use an example, by the way, when Hina was talking about the ratio of men-women ratio, it's something that we can't easily understand, or at least I can't understand, because I'm so far removed from these rules when they were put up to have lands pass through the family for hundreds of years. That's so alien to me as a New Zealander, I can't really fathom it. So it's tricky for me to understand. Anyway, I'll move on. All right. If you own your land in fee simple, do you own everything underneath it? In fact, I'm going to put that as a quiz. Quiz question. Quiz question. Do you own the minerals under your land? Question mark. Go. What do you reckon? Oh, evenly split. Absolutely. Absolutely. That's it. It's well said. Well said, that man. Well said. Abhishek, yep. It is. That is. Yep. That's right. And it's literally on the slide now. You own what is ordinarily accessible. That's the phrase they use in the common law here. So the starting rule is that minerals are natural resources. Yeah, they are. Well, I appreciate that. And Rizvi, the bit of a tricky thing when you think of national resources and the crown, because you appreciate a place like here. And Abhishek, you may be able to highlight in Maharashtra. Is it owned by the state government or the federal government? It is the federal government. Yeah, I think the way your constitution works, the federal government there has a lot more. Uh, it operates amongst a whole bunch of things. The what do you call it? The two lists, consecutive lists that they have in the constitution means that your federal government can do a whole bunch of things. Whereas here, they're actually restricted a little bit more. And they're certainly more restricted in Canada and the United States as well. However, the High Court threw some doubt on this about 20 years ago. The reason for this is that the federal government came into existence in 1901. All right, but up till that point in time, that was the colonies of Queensland, New South Wales, Tasmania, Victoria, and so on. And always, 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 the Crown owned all of the precious stuff beneath the land: coal, gold, silver. In fact, gold and silver were just known as the royal metals. So everything valuable under the land owned by the Crown. All right, it's an important source of government revenue. Now, the High Court cast a little bit of doubt on this. Sri Lanka need permission from the government to do mining. Yeah, exactly. Yeah, you do. And here you do as well. Definitely, definitely do. But it's Abhishek. Yep. Hmm. Yeah, I'll talk about finders' rights if people do go through and find things in a little bit here. Here, um, we know that underneath it all, in order to do mining and to do exploration, there's a series of permits. Australia has a very, very structured system for doing that, and it varies, unfortunately, with each of the states, which is very, very, very annoying. But the common law position with ownership of land comes from these two cases here. They're both UK cases, but they've been followed here by and large. Bernstein and Skyviews involved a guy, very English, very, very stuck up English lord. So these guys had a business where they would fly planes across very, very fancy houses and take photos, and then take the photos and see whether the people wanted to buy them. It was photos of their own manor and their own houses. All right. Anyway, so this guy, not simply content with just saying no, he took them to court and accused them of trespassing while flying over and taking photos. And the British court said, nah. Yes, and we start with the point that yes, in theory, you own everything from the center of the earth to the heavens above in terms of your land, but in practice, it's only what you can actually ordinarily access. It's reasonable use. So, if you can dig a hole as far as you can dig. Oh, yeah, but privacy rights didn't really exist. That's back then. Privacy rights don't even. The airlines would be saying, oh yeah, exactly, Daphne. That's right. Um, it's only things that you can access. And so you have a couple of cases, and look, and the law students do a whole bunch of them where people find caverns underneath, natural caverns underneath their property. Bacado and Star Energy involved oil. That idea that if you have adjacent properties and you put the little drill down, has anyone seen that movie with Daniel Day-Lewis called There Will Be Blood? It's good. It's a really good film. He gets his milkshake and he shows the example of that you go down and then you get your milkshake and you put it sideways and then you take the oil from your neighbor's place because he was a terrible human being. And so that was what they argued about there, whether or not you could actually claim for the things on there. And they said that, look, at the end of the day, you actually only own what you could even get, what you could reasonably access. In a residential property here, you're not going to be able to claim if there was something 25 meters under the soil. We just don't reasonably use it, both probably above and below. Okay, right, some tests. I'm sorry that this part of the subject is a little bit over the show because you're learning some tests about a variety of different things. It feels like it's moving backwards and forwards with a series of rules. This is to do with fixtures and chattels. Okay, so the next 2 slides is about some tests. Historically, we would assess this. I really don't see the point, there is one point, is that it's a good area of law to do law stuff. Here's some rules, apply it to a scenario. All right, I don't think it's particularly useful in terms of information that's helpful for you guys as business people. But nonetheless, I'll explain the rules and we'll assess it, but it's only going to be just a little bit. So it goes like this. Chattels are items that can be picked up and moved around. Okay, so going back to this example here of my living room, example that I had, chattels are items of personal property, including these computers, and other stuff. Not really much here, really. My television, other bits and pieces. And they're things that can be picked up and moved around. That's what a chattel is, right? And it is contrasted with what we call fixtures. Fixtures are things which are items of tangible property, but are affixed to land so as to become a part of the land. And ownership flows to the new owner. So if I sold this house, by default, the air conditioning unit and the fans would go to the new owner. The oven would go. And some other things too. Dishwashers, by the way, usually go. Tiles, absolutely would go, right? But there are actually rules we use to determining this because things get a little bit iffy. For example, here, sorry, my kitchen's a bit messy. All right, this is actually so cool. This is like the first time ever I'd be able to do this in my kitchen. All right. Oh, I should totally have cleaned my kitchen. There's Domino's pizza box. Oh dear. Here we go. So in my kitchen, we have over there is an oven. All right. Again, we would expect that to be attached and associated with it. We would expect the cupboards to still be here if the thing was sold, but we wouldn't expect the fridge. And then we've got things like that. What about the blinds? What about these curtains? What about some things that things might be a little bit iffier? Is there a broken door? Oh, it is actually. The door's just broken. The thing, I can push it back up in place. In fact, I feel like doing it now. Definitely not a pizza box. No, definitely not Pepsi. Oh, great. So there we go. That is, there we go, class. My messy kitchen. But the key thing to know, put the screw back. Okay. Dear oh dear. I don't know of many lecturers who go through and do that. Okay. I'm trying to think of things that are a little bit iffy in this particular place, because sometimes you are going to have things where you would look at it and go, okay, this looks like it should be attached, and then when you rock up to the house and it's not attached. So look, basically the courts use three tests. So you need to know these three tests. All right. The first one, the most important one, is the objective intention test. And that is, what did the parties intend when the particular property, whatever it is sold? And what would the parties intend when the object was put into place? What objectively would people think this particular object, what was the intent at that particular point in time? That's the most important one. Then the next test we can use is what we call the purpose of annexation. That is looking at whether or not, by the fundamental nature and design of the thing, it ought to be a fixture or it ought to be a chattel. That is to do with its essence. What is the nature of the particular thing we're analyzing? Okay, that's the second test. That's if we can't determine the objective intention, we'll use the purpose. And then if we can't think about what the purpose of the thing is, we will use the degree of annexation. That is looking at whether or not the particular thing is firmly attached to the land or not. Okay, so I'm just going to transition this to the next slide because I've explained these in a little bit more depth. Bloop and bloop. Here's the three tests in a sentence. So the objective intention, of course, look, what would a reasonable person think the particular item is? Is it normally, reasonably attached or not? Okay, then we look at the purpose. We look at whether or not the nature and design of the thing means that it should be attached to be used and enjoyed as a fixture or permanently, or should it be used and enjoyed as a chattel and taken up and away? What is the essence of the thing? And finally, the degree, look at whether it's sitting on its own weight, whether or not it can be picked up and removed easily, whether or not, and this is probably the most important bit, whether or not it's going to be removed without causing damage to the land. So some examples. Let's go. So Belgrave Nominees and Barlin Scott Air Conditioning was, as you can imagine, air conditioning units. And there they were trying to work out whether these units, if you picked them up and took them away, whether or not they were going to cause damage. Now they said, look, these things, and they went through all three. They couldn't determine the objective intention. Again, usually you would do this by looking at the contract. That's usually the easy way of doing it. But there they couldn't work that out. So then they had to work it out, well, air conditioning units, usually, 9 times out of 10 when you have air conditioning units, usually they stay. They're not portable. If it was literally a portable air conditioning unit, by its essence and in very nature, it's a chattel. It's portable. You pick it up and you moved it. All right? But if a portable air conditioner had been bolted into the floor and was going to cause a great amount of damage, that is a situation where neither of the first two tests would work, and we would use the third test. So Belgrave Nominees involved air conditioning. Farley and Hawkins was a variety of things. It was actually a family law case. And there, the court had to look at whether the garden shed, because what had happened, a husband, this is really, it's funny, but also quite sad. There was a court order. The wife was allowed the house, the former wife. The husband was allowed everything in the house. What do you think happened then? What would you do if you were told you're allowed all of the chattels and she gets the house? What do you think happened? That's right. Dayancourt and Gregory. Sorry? All chattels. Chattels within the definition of what we've got here. Husband's allowed the chattels. Wife has the real property. So what is the husband going to do? What's his incentive? To go through, take absolutely everything that wasn't bolted down and quite a few things that were bolted down, including the garden shed. He literally picked the shed up and took it. He took the dishwasher. He pulled the oven out. he took away the clothes. There was a clothes hanger thing that clipped onto the side of the house. He took everything, stripped it out. In fact, there was an early case, that Dane Court and Gregor, or something similar, where they again, the you had the tenant, a life tenant, and the remainderman, and the life, oh, it wasn't a life tenant, it was a tenancy for one. I can't remember quite how it worked, but one of them had the desire to take everything. They were allowed all of the chattels, and the other person was going to get the land, so they stripped everything out as much as they could. And the court said, no, these are the tests we use for determining whether those things are. And so Farland Hawkins, they said a dishwasher is usually a fixture. Not because it can't be removed. It can. Dishwashers is actually pretty easy to remove. Just unplug them. Like most of them, some of them have two pipes plus power. Some of them have only one pipe. Sorry, one in. Sorry. All dishwashers have one pipe going out. Some of them have two pipes going in for cold and hot water. Some of them just have one, and they do the heating inside themselves, and then it needs electricity. But what the court said is that when you pull it out, though, it leaves a hole in the kitchen, and it looks ugly. That counts as damage. So those are the things that you look at. Oh, is that? Oh, sorry, guys. I don't want to have another. All right, got to turn that off. I'll reset there. How's that? A little bit better? Good. Yeah, just reset it with the video. Okay. So basically, those are the tests that that you just have to know. You've got to go through, and you look at each of those three tests. So if you got a question like this in either your take-home test or in the exam, and a very, very common thing to do is like, here's 4 items of property. There'll be something like the tiles on the floor that have been custom fitted. So, there might be a cabinet which is been put in, and it's painted to match the logo of the business that put it in. And maybe there'll be a printer which is plugged into the wall but is very heavy, and maybe some blinds again which match the logo of the business has put them in. So what you need to do is you need to go through for every item, use all 3 tests. So you literally would say, look, you'd explain each of the 3 tests, explain it out again, pretty much what's on the slide, but put it in your own words, and then you apply them for each item. Hey, in regards to the tiles, objectively it seems pretty likely that a reasonable person would think that tiles are going to stay and form part of it, regardless of whether they're custom built or not. The purpose of them, the very essence and nature of tiles, is for them to stay, and they have a very high degree of annexation, therefore definitely a fixture. The printer is plugged in and very heavy, but it still sits. The objective intention is probably that it's to be taken away as part of it, because it's usually used as a chattel. By its essence and nature, ordinary printers that print an A4 page are usually not to sort of custom fit to a particular environment. You'd probably pick them up and use them as a chattel. And it has a pretty reasonably low degree of annexation. Even though it's heavy, it's still sitting on its own weight, and it's not going to damage the place if it's removed. Okay, blinds that are custom fitted to a particular building. Again, the objective intention, difficult to say. If blinds were put in by tenants, for example, in a commercial setting, it's possible that they were intended to form part of the land. But if they're custom color coded, the objective intention might be for them to be taken away. Then you look at the essence, again, the purpose of annexation test. The purpose was the purpose of the object to remain part of a particular land, or was it designed in its very nature to be taken away when the new owners left? Difficult to tell. Then you just look at the degree. How much damage is going to be caused by taking the blinds away? And again, that's for you guys based on the facts that are given to you to try and work out whether or not that particular asset is going to be considered to be a fixture or a chattel. At the end of the day, it doesn't matter which answer you have, provided that your reasoning is sound. Does that make sense to you guys? Because it's the sort of thing, it doesn't come up very much when you buy places. By the way, the key thing, very, very important rule, that you need to know when you buy a property, go through the excluded fixtures and the included chattels. What does that mean? It means if something you're not sure about and you're the purchaser and you want it to be there when you rock up, put it in the contract. Literally go through and there's a little box that says included chattels and excluded fixtures. In other words, items that you're trying, that there may be some argument as to whether or not they form part of the land or not, put it in the instrument. That will satisfy the objective intention part. That's the easiest way to go through and do that. Govern it by contract. Don't hopefully have to end up going to court to try and argue these tests for fixtures and chattels. You don't want to be doing that. Okay. Well, do they? Yep, it's good. That's right. Well, you do the three tests. Start with the first one. What would a reasonable person think? Well, difficult to say. Difficult to say, particularly if it's color coded, because you could make an argument one way or the other. A reasonable person might think that it was intended to form part of the land, or they might think it was supposed to be taken away. So you move on to the next test. The second one, the purpose. What in its essence, is its nature to be used as a chattel, or is it in its nature for it to become a fixed for the permanent improvement of land? Again, you might not be able to tell. So then you look at the degree. If the cabinets are taken out, is it going to damage the land? Or if you take the cabinets out, is it going to damage the cabinets? Because both of those things indicate that it's probably supposed to be a fixture. Is it sitting on its own weight, or has it been bolted into the wall? Again, if it's been bolted in place, it's much more likely to be considered to be a fixture than if it's just sitting on its own weight. Because some cabinets, you can have freestanding cabinets that can just sit on their own weight, and sometimes they're bolted to the wall. And so that's for you guys to go through and analyze. And you can make an argument either way. But the key thing to note, I will make it, if it's vague, I want you guys to say it could go either way. You'd need more information. If I have things where it's pretty obvious one way or the other, there's going to be a right and wrong answer. Okay? It's likely that I'll probably put one that's vague and several that are not vague. But either way, you need to use all three tests for each item as part of that. So it's likely that this will be in the take-home test, I would think. This seems like a pretty reasonable sort of thing, because what I found is that it's pretty easy to do the analysis, because you're literally just applying all three tests to every item. But if you think about it, if there were 4 items or 5 items, you're having to do the things 15 times, which is very mechanical, but it can take too long in a 2-hour exam. It's the sort of thing you want to, if you really want sort of half an hour to just sit where you can copy and paste stuff as well. Makes it a little bit easier. Okay, I'm going to move to the next slide here. What are we talking about? All right, going back to some more definitions. Oh, it's so annoying with land order. I said it's just all over the show. So before I made the point about these two terms, chose as in possession and chose as in action, there are some things which you can physically pick up and you can own. Goods that you buy and sell, notes and coins, what we call chose in possession, you can physically pick up. What does that mean? It means you can, if you have a physical bundle of notes, all right, and that's stored in a bag, the rules for possession apply to those things. The rules for detenue, you can ask for that particular thing back, and there's a right that you get to ask for things back, all right? And it has to be those particular notes and coins. Whereas if you ask for your money back from the bank, that's just an electronic number, okay? That is not the same, and we use different rules for asking for it back. All right, there's a chosen possession. So ships, so boats, big bits of capital equipment. Emblements is, by the way, are crops, so things that are on the land which can be picked up and taken away by harvesting. Things that aren't chosen possession are lands and buildings. Though we've already been through that. There are some things though that for other reasons, aren't chosen possession. Human beings and human tissue you cannot own under the common law. The cases, I could put it in. I probably don't even know that case. It's Doddy Wood and Spence. Look, there are some exceptions to that, but the key thing to note that even if you chop your finger off, oh God, it sounds awful when I say that, but you still don't own it. Strictly speaking, you actually don't own your hair. Or sorry, when I say you don't own it, it's not capable of being owned. Even though, yes, there are systems, people where you can grow your hair long and you can go and sell it to people. Strictly speaking, in common law, you actually can't do that by default. You actually can't own humans. Well, I mean, it kind of makes sense as a for policy reason. Owning people is not really cool, and we don't want in any way, shape, or form to have the ability to buy and sell humans. That is quite sacrosanct in our legal system. Airspace, you can't own air. You can't own waterways. Again, these are common law rules. Checks are interesting. Checks, you can own a check, but it's not a chosen possession, even though it's a physical piece of paper, because a physical piece of paper is meaningless. It's absolutely meaningless without the instructions that are on it. Wild animals you can't own. You actually can't. They're not capable of being owned. How do you own them? It sounds quite awful if you capture them. Now, there are statutory rules that stop you from capturing wild animals, but at common law you're still allowed to get animals. Once you take an animal from the wild, you bring it home, you take possession of it, it becomes yours and then capable of being owned. While it is in the wild, it is not a chosen possession. It's not capable of being owned. Asteroids, and you can't own things that are outside because there's no possible way that you can, in theory, physically exert control over it. So things that are out, you can't own the heavens. And you can't own contracts. A contract is a right. It's not a thing. Okay, so let's flip to the next slide. So these are chosen possession. They are things you can do. So that the rules we had when we were talking about tort, choses in possession, you can sue people under trespass to goods if they have your goods and they're doing things with them. And pets, animals are considered to be goods. Somebody does something to your pet, you can sue them in trespass to goods, and in conversion if they do something repugnant to your right to possession, or in detinue if they take, that's the name of a tort, if somebody takes your choses in possession that you are entitled to possess and they do not give it back when you ask them, you can sue them in detinue. All right, and the elements for those torts we talked about in week 8. That's a similar thing, but it has to be in those sort of category of things capable of being owned. Now, in the next slide, we're talking about what we call choses in action. These are the intangible sort of properties that we have, and these form two classes. We have what's called legal choses in action, and we have equitable choses in action. Okay, so a debt. If somebody owes you a debt, that's a right. It's a right in our legal system, a common law, but you can't see it. We know the right exists, and assuming that you can prove it, usually with documents, although strictly speaking, that can be oral. It's really up to you to prove things. That we call that a legal chosen action. Contractual rights that you get under a contract. If I purchase Australian pigeons in another country, is that illegal? Under statute, illegal, a variety of things there. What you'll find is that if you purchase something lawfully in another country and you bring it into Australia, the statutory mechanism may prevent you from owning it here. Pigeons are pretty straightforward because that's the sort of thing that's under that'll be governed under statute because there'll be certain types of products. Ivory is perhaps a better example. If you have ivory and you purchase it and you bring it into Australia, it's I'm pretty sure with the process of you importing it in, I think you can't lawfully do that, and I believe that it is just taken off you at the time, but I'd have to check that. A better example might be, again, human organs. It sounds a little bit grim, things that aren't capable of being owned under the common law here. If you bring it in without any form of statutory obligation, when you bring it in here, you cannot own that thing. It is not capable of being owned in our legal system at common law. Again, statutory rules can trump all of these things. Next week, we'll talk about copyright, patents, trademarks, and designs. That's intellectual property. We'll spend a whole week on it. Shares are chosen action. It's something you can't see. Your right to own a fraction of a company is an intangible right. In law, these are all considered or put in the same category of things. A bank account is a right to ask a bank to give you some money. A check is a right to ask the bank to pay some money as a negotiable instrument. A legal charge and security interest, that is a mortgage that is placed upon something. So in other words, you've lent somebody something, and if they some money, and they've guaranteed that loan by offering up some property, either real or personal property. If it's real property, call that a mortgage. Otherwise, it's a charge. So, for example, if I borrowed $1,000 from Hina, then she said, "Okay, that's fine, but if you don't pay me back within 12 months, I'll take your car." And we again put that into an instrument. That means that there is a security interest on my car. Business names, that's a chosen action. You have a business, but the name itself doesn't really exist anywhere. It's an entry in a database somewhere. Your reputation, business reputation, you can sue people who damage your reputation at common law. It's not an equitable action, it's a common law action. Same with goodwill. Goodwill in accounting has a very technical meaning. In law, goodwill is I'm not too sure whether it's given. I think it's given something of a different meaning because it's capable of being damaged, but it is not merely the difference between all of an entity's assets when it's sold and the extra bit left over, which I believe in accounting. It's been a while since I've done accounting, but I believe that when you sell a particular business, you add up the cost of all of the assets that that business has, and then the bit extra over, the premium you pay, is the amount of goodwill when you buy businesses as a going concern. Is that right, Tala? Oh, boo. Okay. Oh, so they're included as part of it. So again, I actually did I did accounting under the old um, accounting standards. So it was just before they moved to um, global stuff. And so one of the things we had to argue about, this is 2002, was that certain types of brands, things like logo. So the New Zealand Herald, for example, would have its particular letterhead, and at the time we weren't allowed to value it on balance sheets. So the breweries as well would have that too. Yeah, I have too many degrees. Yeah, way too many. Too much time at uni. Yeah, it's funny. Hey, I'm not sounding. I'm not. I don't sound proud. Um, but the idea of that you weren't allowed under the accounting standards at the time to value your brand and to value that aspect of it. And so the trouble was that some entities, like the breweries, if you took the brands away, thanks, Ravneet, you're too kind. Um, if you took the brand value of the breweries away, they were all insolvent. So that was a real problem because we know that brands are worth something. If somebody could sell me, uh, how much would you pay for the Coca-Cola brand? It's worth literally tens of billions of dollars. We know this, but it's an intangible thing. And so what they found to get around the fact that our accounting standards at the time in New Zealand wouldn't do that, like Coca-Cola brand is, yeah, that's right. Oh, yeah, much, much, much more. But the easiest way, or sorry, the best way to value something is to actually go and sell it. So if you think about it, if you weren't allowed to put it on the balance sheet because the accounting society and parliament said no, all you would have to do, and this is what Credit Suisse and people like that would do, is that you would sell your brand. Sell it to a third party and lease it back off them for an arm's length value. And so what you do is you would have companies, again, Lion Breweries in New Zealand would do this. They would go and they would have their they would have the brand for the beer, the Lion Red beer, and Export Gold and Tui. And if you ever go to New Zealand, you've got a Tui. You'll try all those different beers, um, or not, Hina, or not. Um, and you can take that, sell it, and then lease it back. Why? Because it means that it had value. You've sold it, and you're leasing it back off them. And usually, you wouldn't exchange money as part of it. So if we think about it, that was a mechanism to get around the standards of the time. So that way that brands were actually worth something different and distinct from what the goodwill component was when we were doing it, but they were all blurred into one. But that was to do with accounting standards, and unfortunately, I haven't kept up with that in the last 20 years. So apologies. Bare rights to sue. The right, if you have a right to sue in contract or tort, that is chosen action. That's something that at common law you can have. And look, there are mechanisms to assign those rights. If we go through all of those things there are statutory ways that you can take those things, those 11 items there, and sell them. Actually, assign them to other people. You can do that legally. However, with equitable interest, things are a little bit trickier. You can still assign these things, but it has to be done under the Property Law Act, and it must be done for valuable consideration, must be done in writing, and must be done with clear intention. So you actually can't sell those things: confidential information, rights to future royalties, future property, equitable securities, that's unregistered mortgages, rights of beneficiary and fiduciary relationship, or a partnership or trust fund. So these things that have that are created in the area of law we know as equity, these things can only be done and moved under the Property Law Act. You can still assign them, but it has to be done informally. And usually they're done in the form of a deed as part of doing that. Okay. All right. Oh, in fact, speaking of which, on the next slide, I even write: equitable chosen action can be assigned only with clear intention, writing, and notice. Oh, notice, sorry, this is the other thing. It has to go to other parties. So that if you wish to assign some things, there's equitable things. So beneficial interests in a trust, you can actually assign that to someone else. So if, for example, I have a trust that's set up with myself and my child, so I'm the trustee, got the child, me as the beneficiaries. In theory, when he's either I or him could actually take our equitable interests and assign it to another person, which would be pretty scary, but could be done. Okay, so just also note that when we think about the word ownership, this is really more a theory part, this bit here. We think about ownership. Ownership is a packet of rights, and which I've listed there, is that when it's your stuff, it's your stuff. You get, by default, at common law, you get to do with it however you like. It's your stuff. If you have your is it perhaps a poor example? Is a textbook? No. Okay, here's my child's label maker. He loves this label maker. All right, and in theory, it's his. Oh, that's not a particularly good example because. No, okay, no, same. Assuming this is his. So my child has this label maker. It's his. He owns it. He has the right to demand immediate possession of it. I mean, if I put it somewhere high above, he's not going to be able to demand anything he likes. He can lease it, hire it, allow others to use it. Yes, he could sell it. He can give it away, and he can leave it in his will. He could place a charge on it or mortgage it. In other words, he could actually borrow money with this as security. So if he doesn't pay the loan back, the person that he loaned the money to would end up having ownership of the property. He can consume it. He can destroy it. He can damage. He can do what he likes with it. He can throw it away. And he gets the right to sue in tort. So if somebody damages it, if somebody refuses to give it back to him, he can sue them because his rights have been infringed in regards to that particular thing that he owns. And that applies both to real property, it applies to personal property, and tangible and intangible. You have a packet of rights. However, in some situations, they're not unfettered. So Parliament jumps in and stop some things, and the common law in some places. So I mentioned the point about life tenants. Life tenants can't waste property. They've been granted an estate. They can live and use and do whatever they like with the property, but they have to leave it in a minimally well-maintained condition for the remainder men. If you want to sell a car with registration, all right, it has to have, it must be registered in order to be sold. You can't just sell a car that's registered to another person. The statute won't let you. You can't, an owner of a heritage listed building can't do whatever they like with it. They cannot choose to knock it down and put in a new one. You just can't do that. Similarly, here, said I'm in Douglas, I can't set up an abattoir in Douglas. I'm forbidden under the planning regime from doing that. So that when we say that we have this packet of rights, they're often abrogated or curtailed in some way, both by common law and by statute. Okay. Next slide. Possession. I have mapped this one out a little bit more, so we might, yeah, this one will probably go in the possession and finder's rights will probably go. I think I put it in the exam last year. Okay, because possession, and this is interesting, that case of Armory and Delamere, for example, possession, you might have heard of this phrase, possession is 9/10 of the law. What does that mean? It means the person who has the thing has the best rights against everyone else in the world other than the true owner of the thing. What does that mean? It means if you find something, if you are walking through the bush and you find a diamond ring, okay, you have a better right to that ring than anyone else in the world other than its true owner. Okay? So you have the best right. So in Armory and Delamere, that actually happened. It was a chimney sweep. All right? It's a very poor person. Yeah, Tala, yeah. Essentially, if the true owner can't be located. That's the key thing. The true owner, if they come along and say, "Oh, that's my ring," and they can prove it. Oh, we'll get to that. It's on the next slide, actually. Burn Hall is the case. It's on the next slide. I'll get to that in a tick. Okay. So Armory and Delamere involved a chimney sweep back in the old days. So went through, was cleaning a chimney, found a diamond ring, a ring with some precious stones on it, took it to the jeweler, all right, and the jeweler took the stones off and replaced them with cheaper stones, all right. And then when the person who found it came back, they tried to sue, and so they actually went to court. And it was actually held the chimney sweep had the best rights to that ring. The true owner couldn't be found. Therefore, the jeweler couldn't do that. The person who found the thing had the best rights. Okay? And so as a result, and they didn't give those by giving it or under what they call a bailment to the jeweler to look at the stones and examine it, didn't give away any of those rights as the finder, and so they had the best packet of rights, and as such, the stones belonged to them. Okay, a couple of other things to note. Possession is an interesting thing. It's defined in the common law. A lot of these cases obviously involve drug cases, but possession in our legal system has a mental element. Right? You cannot be in possession if you do not know of the existence of something. Okay? So if something is placed on your person and you do not know about it, you aren't deemed to be in possession of it from the meaning of the word. Even though ordinarily we would think that something that you're holding, was examples, my keys, for example. All right? It has an element of possession. Now, possession also, though, includes things that you have control over. So while I can arguably, I have possession of my keys because I'm holding them in my hand now, right? If I put them down on the table, I'm still deemed to be in possession of them there. I have I've got knowledge of them and the ability to exert physical control over them as well. It also means if they were sitting at my office at uni, I'm also deemed to be in possession of them as well. It's the ability for me to exert physical control over things. Okay. So just make note that it doesn't have the ordinary meaning. It's modified somewhat from the ordinary meaning. Okay, so that's possession. Again, possessions are usually it's a very, very weak right. Now, going back to this idea of the person who has possession having the best right, is the next slide, because exactly that. And again, I had historically put this in the exam. I put it in the exam last year. It's a pretty simple series of tests, which is why it's sometimes it's a good law question, but it's not very useful in terms of business law, I don't think. So it goes like this. Exactly. I think was it Nathan? Oh, sorry, I'm just going to check the little chat. Who'd mentioned it? Oh yeah, no, it was Nathan. Yes. If you find a public place, e.g. Stockland. Okay. If you find something in a common area, all right, that gives you as the finder the best right to that object. And so that's what happened in Parker and the British Airways Board. All right, the guy found it in the club, not the Qantas Club, the first class lounge. We won't have the exam. I'm not going to put a lot of it in the exam, I don't think. Look, I mean, I can if you want, but I don't think it's going to be that. I just don't think it's very useful. From your guys' perspective, I want you guys to think like good, solid business people going out and making good business decisions. And some of these areas of law, the Accounting Society makes us teach this, and because they want you to be well-rounded in a variety of areas, so that it's much more likely I'll ask probably some questions about leases. I would think to me that seems a little bit better, but I could, might put something like this. But I haven't actually written the exam yet, so I can't really answer that. I have to fess up. I've only just found out what day we're going to have it on, so that's good. Okay, so make it easy, please. It would that is the one thing I can guarantee you I will do. It will be easier than previous years. It'll be easier. Oh, it's shorter. It's only 30% as well. So that's it. So what I usually do with these exams is that I want to make the first 15 marks really, really easy to get, and then you have a diminishing return. In fact, you guys, when you did the semester test, you would have noticed this. The test, I think I said that there were some questions that were really easy, and then later on, there's some questions there that are going to be really hard. And the question was, how will we know they're hard? I'm like, oh, you'll know. When you did that test, yeah, you knew. All right. So anyway, Mr. Parker, he was in the first class lounge, and he found a gold bracelet. Not that funny. No, not that funny. Sorry. Yeah, not that funny. So he found a gold bracelet, and so he took the gold bracelet, picked it up, and said, "Hey," went to the staff, say, "Hey, look, I found this gold bracelet. It's sitting there. There was no one else in the lounge. I'm handing it in, all right. But if no one else, it's quite a nice bracelet. If no one else claims it, can I have it?" So the staff took it and said, "Look, I don't know what our policy is." So they took it away. Anyway, he ended up suing them for the gold bracelet because they took it away, and I think they lost it actually. But they tried to argue that they weren't, not that they weren't liable. They tried to argue that they owned it because they owned the lounge. If you think about it, like, who has the best claim here? If you find something in Stockland, should the people who own Stockland have the right to it? And there the court said, and this is the rule. The rule is, look, normally, if you find something at somebody's house or somebody's place, they're going to have the best right. However, they have to be actively exerting control over that particular area as part and parcel of it. And so this is this key thing. And there they said that in the case of their lounge, the staff weren't actively exerting control over the entire area. Therefore, Mr. Parker had the best right in regards to the gold bracelet. Okay, that is literally just the rule. If you find something, if it's in an open space, JCU would be a good example. So if we were in the tute room and I'm running the tute and somebody points to something and said, "Oh, look, there's a gold bracelet under that desk there," arguably, while I'm there as a JCU employee, I am actively exerting control over the entire space. So if it was in a tute, if you found something, arguably JCU, through agency, through me, who's being paid by them, is exerting control over that area. If, however, you found the thing after the class had finished and I'd left the room, then JCU is not actively exerting control over that room. All right, and you would have the better claim than the university over that item. That is literally how the rule works. That's a pretty good example. Bizarre that I haven't thought of that until this class this year, but that's essentially how that works. Okay, if you find something though and it's stuck to the land, that creates an extra little bit of complication. And so Yules and Briggs Gas involved a boat. It was what they call it, a Viking boat. Some guy went and found, I think he was walking his dog or something similar, and found this boat on land that belonged to the gas company. And so they had to argue whether or not this particular thing, in this case it was an ancient Viking boat, was owned by the person who found it, or whether it was owned by the gas company. And there they said it's the gas company. Why? Because it's very heavily attached to the land itself. Sure, you found it, but it's still a fixture. It's still very much attached to the land. The fact that you found it doesn't change the fact it's a part of the land itself. That belongs to the gas company in that particular case. We contrast that with the South Stavanger water case, which was a ring which was stuck onto the bottom of a swimming pool. And a person was able to get the thing and pull it out. And there the court said, look, it's not attached enough. And as such, even though it was attached, now it's off. Yeah, on balance of things, it's Mr. Sharman will get to keep that particular ring. Okay, so that's finder's rights. Again, this stuff doesn't come up much. It almost exclusively comes up in your personal life. Very, very rare it comes up in business life. However, an important thing to note for those that are going to have employees or who are employees, if you find things in the scope of your employment, by default, you've got to give those things to your employer. Okay, as part and parcel of it. That is the default rule. That is the standard rule. All right. However, it must be in the scope of employment. So Bernard and Hoare was a police officer in Mount Isa, I believe, who was paid, for whatever reason, there were these drive-through movie theaters, and the movie theater had paid some police officers somehow. It had some arrangement with the police for them to come and look out for children being delinquents at this movie theater. And so one of them found a packet of money. All right, and so to argue that, look, strictly speaking, he was doing it, but being paid overtime. And there the court said that actually, look, if he was a beat cop and he was walking down the street, on Flinders Street on Friday night, found some money, that's in the scope of employment. All right, while he's sitting there managing drive-through movie theaters, being paid overtime, that wasn't found within the scope of employment. Therefore, the officer was allowed to keep it in that case. It's a little bit odd, that particular test. And really, it comes down to what are the things that you are doing in your job. If you're a cleaner and you're cleaning out a bus, all right, anything you're going to find is going to be found within the scope of your employment. It just is. If you're cleaning the bus and then you've got a break, 5-minute, even a paid break, and you walk to the shops, and on the way, still on the land, you found something on your way to your break, probably not found within the scope of your employment. Yeah, it's a little bit odd, these sorts of rules. And again, they don't come up very much. Just make note, if people are doing their job, and as part of their doing job, they pick up something and they find it, it's going to belong to the employer. That's pretty much the main rule that comes from those cases. Right, what are we? Oh, I've got a couple of minutes. I've only got a couple of slides left. Bailment. We're going to learn about bailment and liens. And, okay, you haven't got much to go. All right. Yeah, we're not going to take a break. No, we've got 20 minutes to go. All right. Bailment is a legal technical term to describe a completely different area of law. It's completely different from anything else. It's quite different from contract and tort. In fact, that's that Greenwood case. It's actually much older than both contract and tort. So stop and think about it for a second. This area of law predates private deal making. It predates the idea of seeking compensation from others that infringe your right. Bailment is ancient. Bailment goes back to the idea of, strictly speaking, a quasi-criminal nature, where if you are an agrarian society, all right, and stop and think about this. And I gave that history of history of civilization in week 2, and I talked about the Levant, the Fertile Crescent in the Levant, going from modern day Israel all the way up through to Iraq and Kuwait, and the Tigris and Euphrates. That very, very, very early ancient farming communities. The first real agrarian societies. We're talking 10,000 years ago. That if you think about it, if you are in charge of the village's goats, all right, and you lose them, what happens to everyone? What happens if you lose all of the cattle? If 10,000 years ago you're in an agrarian society, all right, and you survive on, having, cattle, goats, sheep, cows, what hell have you, and somebody goes and loses them all, or damages them, or kills them, what's going to happen to everyone else? Yeah, if you've got a society where you survive, you literally survive by farming, and he said, and by having cattle. So again, sheep, cows, pigs, the goats. All right, and if one person in the community, yeah, everyone dies. That's what I'm getting at. Thanks, Marie. As such, if you fail to take good care of things that everyone needs, everyone's going to die. And so if we go, and this, I said, this predates Roman law by a long way. Yeah, there you go, Enrico. Have a think about that. Predates Roman law. If you didn't have rules in place to stop people from letting the goats and pigs, whatever you, go away and dying, you're going to have rules in place. If you didn't have this, everyone's going to die. Somebody will go off, somebody will be delinquent, and that's a real problem. So this is ancient law, the idea of bailment. And again, it would have been, going back 10,000 years ago, it would have been what we call quasi-criminal. You would have been punished for damaging things. It's where you've got everything's communal property. There's no concept of compensation. And so that when I say bailment is different, distinct from contract, and it predates both, it's because it flows from very, very ancient concepts and the need to look after stuff. Okay? This is the idea of that when somebody gives somebody else stuff to look after, there is a rule at common law that that person taking the thing has to look after it. All right? But in our legal system, it's actually a pretty low bar in terms of the standard of care that you have. You might have noticed that I've talked about duties quite a lot, the duties that we have. So you have a duty of care in tort, for example, where if you're owed a duty of care, solicitor, client, doctor, patient, accountant, client, owner of land, occupier land, you owe a duty of care, and you have to maintain a standard of a reasonably competent doctor, solicitor, owner of land, and so on like that. And if you fall below that, you can be liable to compensate somebody if that causes harm. Sure, that's a duty in tort. We also have duties in contract law to fulfill what we said we were going to do. And those are a little bit higher because when we promise things, we can promise things that we will do certain things and we must jump through. And if we don't do what we said we're going to do, even if it's not our fault, we're going to be held liable. And even higher again with the fiduciary duties. If you are a trustee, you must look after the interests of the beneficiary. The law will hold you accountable very, very, very strictly. You will be liable to compensate them very handsomely if you fail in that duty. Fiduciary duties are the highest ones. There are some statutory duties as well. You know, in a criminal code, for example, you have a duty if you're doing dangerous things or you've got dangerous objects. But by and large, in civil law, fiduciary duties, then we've got duties under contract, then we've got duties in tort, and then way down here, we have duties in terms of bailment. All right. Bailment is actually a pretty low bar. You have a duty to take reasonable care of stuff if it's given to you. Now, bailment can coexist with other areas of law, particularly contract. And so that this idea of bailment will still apply where there is no contract. So just make note, even if you've got no contract with somebody, if you've taken their stuff or they've taken your stuff, you still have these duties. These things still apply. And they will still apply, but the standard is pretty low, especially if you're not getting paid as part and parcel of it. Bailment can also exist between family members. So again, bailment is, so if your sister goes and borrows your car and crashes it, right, because she's driven like crazy, you don't have a contract with her, you can't, she's your sister. And, well, I mean, you probably can't, Homogeneous Greek Orthodox Church. But she still has a duty to take reasonable care of your stuff. That's it. So that here, where one person takes possession of the goods of another, that's the bailee is the person taking possession, and the bailor is the person giving it away. The bailor giving away, bailee taking it. And there are some duties of common law. They are not particularly rigorous, at least not for what we call gratuitous bailments. So if, in other words, when no money is exchanging hands, they're not particularly high. They're a little bit higher when money is changing hands. Okay, so duty, and these are just things the common law imposes. If you take someone's stuff, you've got a duty to take reasonable care of them, retain possession of them, in other words, don't throw them away or give them away. Don't make unauthorized use of them, don't let other people use them unless they're allowed to, and return them in due course, usually after the particular purpose that you've been given the stuff is done for. The bailor actually has duties as well. When you give somebody some stuff, you have a duty to actually give them the thing. Again, usually if there's an arrangement to go through and do that. Don't interfere with them if they've been done for a specific purpose. Again, if you see somebody with your stuff, if I've lent something to somebody, you can revoke the bailment, go and pick the things up to end it. That ends the bailment, assuming there's no contract. You must tell somebody if they are dangerous. Okay, here we go. So this is a bit where if you give something to somebody, even if there's no contract and there's no duty in tort, if the things are dangerous, you have a common law duty to tell them as part and parcel of that. And if somebody's hiring something, again, hiring something even in absence of a contract, somebody, although hiring usually means there is, but if there's some sort of defect on it, they have to be merchantable and fit to purpose at common law. Okay, so what are some rules for bailment? Here we go. Oh, have I got it there? No, it's down here. We're almost done, guys. I probably will put bailment into the assessment somewhere. It's pretty, I mean, it does happen. Look, usually it happens with things, things like car parks and stuff like that. Or another one can be if a person's bought stuff off you and never paid for it. So the contract, whatever reason, the contract never comes through, or they say they're going to do it, but a contract isn't formed. All right, and so the stuff is still sitting, can be sitting there, or goods have been delivered and are ready to be taken back. You somehow in life, because it happens, guys. If you think about it, sometimes you just end up with other people's stuff. I mean, who here has had to look after other people's stuff in their garage at some stage, or have left their stuff in somebody else's garage? Does this happen for anybody here? Tala. What sort of things? Oh, yeah, during the floods. Hina's just made the comment there. During the floods it happened. Yeah, that did. That happened a lot, actually. Yeah, good point. Um, yeah, we do. We end up with stuff. Abhishek. African what? What was the noun? Sorry, African. Grey parrots. Oh wow. Okay. Cool. Yeah, that's a thing. Yeah, it's a thing. That's true. That's a bailment. You end up. Were you voluntary as a bailee? Oh, nice. Oh, very cool. Yeah, that's it. And look, people have pets are actually a good example. Obviously, it's much more common here in Australia and in New Zealand, where people go away and they leave you their cat. Do you have a duty? You actually do. You've got a duty at common law. If you do it voluntarily, all right, you've got a pretty low standard. If you are an involuntary, so in other words, somebody's dumped it, and not even asked you, um, then the standard of care is even lower again. All right, so and that can happen again if you had a housemate who just went away and left their stuff, left you and with stuff in the, either in the house or a cat or what have you. That can happen. Okay, so subjective tests. So we use a reasonable person test for determining whether or not what their standard of care is. It's whether what would a reasonable person in the situation think it is. If it's a professional situation, if either you hold yourself out to be a person who deals with these particular goods, all right, or you're doing it for money, even if that money, for whatever reason, that it turns out to not be a contract. So that if it's this commercial bailee, so a person, for example, who takes has car parks, for example, you've got Wilson's car parks. In that idea of that when you go into a car park, you get a little ticket and you do. In fact, most of these cases, by the way, Mitchell and Ealing, Graham and Voigt, I believe, not sure of the other ones. It's a boat case, not the ones at the bottom. But most of the cases when I've done research in this area has been car parks. There's heaps of them, heaps of car park cases where people park their cars and there's, for whatever reason, there's no contract whether or not the car parking people are liable. So just make note. If you hold yourself out to be a person who deals with this particular type of goods or service or acts as a bailee, then you have a higher standard than others. And you can contract out of the common law rules for bailment. Okay, you can contract out, so you can have an agreement which overrides these rules, either to increase, or decrease the standard of care required. And you can actually do this without, when I say by agreement, it's actually broader than just contracts. So that you can have an arrangement, and again, this can happen between family members, where you say, and I've literally had it. In fact, my friend Steve, he said this to me. This is back in the 90s. He's like, Simon, he'd had a few drinks. Can you go and pick up something or other? You can take my car. And he had I don't know if anybody cares about cars. He had an R32 Skyline. This was a big deal back in 1998. He gave me his keys and he said, stop. And he grabbed my hand and said, Simon, if you do this, you are taking full financial responsibility for everything involved with that vehicle. And I'm like, oh yeah, sure, okay. Now, by doing that, that's not a contract, but it does modify the rules for bailment. So you can leave that one in the back of your head. If you have an agreement, even with a family member, you can change the level of care that is required with your stuff. Okay? So, when you are dealing with your family from now on and they're doing things with your stuff, just make sure it is clear and put it in writing, particularly email. Hey, yeah, sure, I'll look after your cat. I'm going to stand it, but I can't guarantee. Your cat's kind of old. I'll do the best I can, but I really don't want to guarantee that. I don't want to be liable for any vet bills, for example. Just map it out ahead of time. Even if it's not a contract, map out what's going to happen as part and parcel of it. And that will modify the rules of bailment. Okay. There's a question. I haven't had an argument with Steve about this. I'm going to have an argument about it. Bailments are not always fiduciary relationships. They actually can be, though, in some circumstances where goods are imparted from bailor to bailee in circumstances where they're doing bad things with them is going to trigger the rules of equity. In other words, it'll be unconscionable to do things. So an example of that might be when somebody gives you their some sentimentally valuable thing, and they say, please, please, please be careful, and you just shrug your shoulders and say whatever. In other words, you don't agree to it, so the common law rules are going to apply. Or if you know that something's sentimental and you've accidentally ended up being with it, you've become an involuntary bailee of something. Your flatmate, for example, left their mother's valuable necklace there, and you've seen it. You know that it's very sentimental, but you just don't care. Look, if equity requires it, you can be held as a fiduciary relation. In other words, instead of having a very, very, very low standard, actually be held to a very high standard going through and doing that. But it's only in narrow circumstances where it's going to be in bad conscience for the other person to not have the ordinary standards of bailment. It's not all bailments, and I'm going to have an argument with Steve Rohr about it, because it's when reading the textbook, I'm not sure he's made that expressly clear, but I'll follow up on that one. It's possible he didn't even write that chapter, which is I'll also find out. Okay, that's all we really need to know about bailment. Look, it's just a series of common law rules. Yep, Hina? Yes. If somebody has parked a car in your driveway, okay? They've parked a car in your driveway. You don't want them to be in your driveway, okay? What are you going to do? What do you think you're allowed to do here? Do you have to insure that car? Do you have to stone it? Yeah, nice. No, you don't. But you can't damage it and push it out of the way. Okay? You've become an involuntary bailee. You do not have the right to damage that particular car or vehicle. Oh, I know, it's not fair, is it? I know, right? I know. You have to take reasonable steps. What would reasonable steps be if there's a car in the driveway? Set it on fire. Yeah, nice. Reasonable steps arguably would be to call the council. Yeah, probably not 000. You'd probably call the local council and say, hey, there's a car in my... And they can park and those things there. Again, you can end up being in possession of stuff. Similarly, you may end up in possession of colleagues. If you're working in an office, you may end up being in possession of things. Say somebody leaves, but they've left some objects with you. All right, you have to take reasonable care of them, but it's a very low bar. All right, if they come back and say, "Oh, where's my pot plant?" or "Where's my," cats are particularly problematic. "Where's my cat?" Reasonable steps, reasonable amount of care, yeah, so that you can't, get the local kids, smash the window to get the thing to move it. You can't do that. Reasonable steps. Well, again, it's a reasonable person test. What do you guys think a reasonable series of steps are? Probably to call the council. Possibly also to get, maybe a tow truck to come and move it, or maybe it's to get it out of the way. But you can't just destroy the thing. You're not allowed to. Well, I mean, you can, but you're going to be liable by default, even though it seems a little unfair, because you become an involuntary bailee of things. That's how that's just literally just how the common law works in regards to those things. Again, there's statutory mechanisms for this. If somebody parks literally in your driveway, you may have rights, remember, under other areas of law. So if somebody's parked in your driveway, you might have rights in terms of trespass. So you may be able to have an action. And look, to be honest, if push came to shove and you both go to court, you might win more money, maybe, because you can demonstrate harm. Hey, I couldn't get in and out of my house. But by default, you can't smash up their car. That's just the rules. That's just the rules of bailment. That's pretty much just how it works. Okay, really, really quickly, the last two slides. Liens. A lien is a particular right at common law when you are doing work on something, or somehow you end up having possession of another person's chattels and they owe you money. You have a right to retain the thing until they have paid for the particular service. The classic example of this: who has ever gone to get their car repaired somewhere? Yep, you have that. Um, think about where they park the car after they've done the work on it. Do they just park it outside so you could just rock up and grab it and drive away? Oh, no, they don't. No, they don't. They retain possession. So they will either keep it in their yard, or they will often mechanically disable cars. You take out, it used to be the rotor. I don't even know what modern cars they pull out, something. Um, unplug something. So a person can't just rock up, get the car, and leave without paying for it. All right? So that's right. Now, common law, you don't get power of sale. You do not get a right to go through and do that. All right? So that's a general, not general lien. No, that's a special lien. General lien is an unusual type of lien. So liens, by the way, is just that idea. It's retaining possession of something until you've been paid. That's just what it is. You don't get a right of common law to sell it. You do get some rights under statutes. I don't know whether motor vehicles, they might be a right to do. I know that guys that do boats do. There was a guy, and I remember this. My father took a boat into this guy. It's like 25 years ago when I worked at the petrol station, and the guy eventually, my dad never came to pick the boat up after like ages, months, 6 months, a year, I can't remember, ages. And so the guy took the boat out, moved it, and then took it out, and then went duck hunting, and then it sank. And so my father was kind of grumpy about this and wanted to try and sue him. Yeah, not sure whether he would have won. But that's a special lien. That's the one at the bottom. That's enables lien to retain possession of the property only until payment of the charges which have been incurred in relation to the property held. The thing has to have a connection. Hey, I've done work on this boat. I'd like to be paid for that work, please, and I will keep the boat until that's been paid for. There was a case earlier, Hawker Pacific, involving helicopters, something similar that we did when we were talking about duress. Okay, all right. Now there is a special. Sorry, it's not special. It's called a general lien. Yep. Yep. Mm. What? Hang on. Well, if you're contesting the, hang on. Oh, yep. Mm. Yep. Sure. Well, you've got other areas of. No, you've got other areas. No, you can. Sorry. So hang on. So you've they've done work on your car, and then they work. You come out and you get your car, and you find that it's no good. Is that right? And then, yeah, yeah, they can keep your car. The common law. They can actually. They can until that's paid, and then the common law, and then you can go and seek remedy under the Australian consumer law. Just yeah, yeah, yep. Oh, okay. Um, Yeah, you wouldn't. I don't think you'd get by with that here. I've just noticed that the screen, Google's just having a go, so I may just have to. I can hear you guys. Can you guys still hear me? No, it's odd. My screen has crashed, but the audio is still working. It's very, very strange. Which means I may not be able to go to the last slide, which is kind of funny. Because I was going to talk about the very last slide, although again, it's probably not that important. It's just a couple of things to need to know is that you are actually allowed to do it, and the this general lien only this is idea that you can hold and retain possessions of things, including things like documents. That's only available to those four types of professions: bankers, stockbrokers, insurance brokers, and solicitors. So we get a right to have a lien across your matter until it's been things have been paid for. So that's what we can go through and do. It is still actionable law, and very unfortunate. I want to just go to the next slide, but I actually don't know whether I can. I think Chrome's just died on me. I can put it on YouTube, so if you do want to go to the very, very, very last slide, and I was going to talk about this case, Irving and Heffernan, because it's hilarious, and it's a Townsville case. And so it goes like this. I'll move to the very, very last slide. It's actually just to do with innkeepers. There's two types of unusual professions: common carriers and innkeepers. Common carrier is somebody who holds himself out to carry goods and can't refuse people from having goods, which very, very few people are common carriers these days. But innkeepers are interesting in that they, a common law, they're people that receive travelers and give them lodging. So, in other words, you have it in a hotel of some sort. Now, curiously, um, innkeepers, as the people that run hotels, they have to compensate you if your stuff is stolen from the room. Okay? So think about that. So if you go to a place, the innkeeper, the people who run the hotel, they have to compensate you if your stuff is stolen from the rooms, and they can take your stuff and hold it as security. In other words, take a lien on it if you haven't paid for the accommodation. It's a very unusual area because both sides have liability under the common law to each other. It's a very, very curious case. And so in Irving and Heffernan, which is the final slide, again, you guys, if you've got the slides in front of you, I can't flick them here because Chrome's crashed. In Irving and Heffernan, strictly speaking, it's a criminal matter, but I went to the Queensland Court of Appeal. It was in Townsville. It's actually the Vale Hotel. So if you guys go to that Dan Murphy's in Aikenvale, and you've got the Vale Hotel, and behind it, there's some accommodation, this ugly brick building. Anyway, a guy came into that one day, and this is back, it's about 30 years ago. So he used their phone, and he made a lot of toll calls. So it was going to be charged. So the innkeeper, the hotel manager, went into him and said, "Oh, you got to pay for these calls." And the guy was half asleep. He says, "Nah, go away." Goes back to sleep. So the innkeeper went and grabbed the guy's wallet and grabbed a bag. And the bag contained, as they found out later, so the wallet contained a bunch of cash, and the bag contained a whole bunch of marijuana. And the reason this went to court is that you can only adduce evidence to court that has been obtained lawfully. And so what they were having to argue, even though this is a civil matter, this had to go to the Queensland Court of Appeal, because the Court of Appeal had, both sides were arguing, one way and the other, that the particular situation, the innkeeper was lawfully allowed to take the wallet, and whether or not they were lawfully allowed to take the bag. And there they said, look, the common law innkeeper's lien says an innkeeper that hasn't been paid is allowed to take possessions, but not allowed to take money. And so that the wallet was unlawfully obtained, but the bag was not. Can you guys still hear me? I think we might be gone. which is a bit of a shame. Yeah, I think it's really just cracked it now. So I'm going to probably leave it there. Anyway, that's the innkeeper's lien. It's limited to $250. I'm going to leave it there, guys, because the whole thing's crashed on me. So I'll pop back into the session just to turn it off. But I hope this was useful. And like I said, we're going to carry on next week, and I'll have to go and have a little chat to everybody about the changes to the assessment. So I'll leave the stream there. Good night all from the stream, and I'll jump into the Collaborate session just to restart that now. So thanks, guys. I hope that was useful.